Someone here on Shire v. Shire?
Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Read here, all persons having business with the Appellate Division. You are here, give your attendance, and you shall be heard.
Good afternoon, and welcome to the Appellate Division First Department. I am sure most of you know the drill. We are familiar with your cases, the briefs, the record. So please ask for only the time you actually need, not the time that you want, understanding that the clock is for you, not for us. So if we have more questions, we can go beyond the light, all right? And if you do that, I won't have to do it for you. Okay. People versus Sharif Moses. Four and 2 and 4. Great start. Lettieri versus Port Authority of New York and New Jersey. Five and 1 and 5. M. Tierin is submitted. Alrose Steinway versus Jaspin Schlesinger.
Good morning, Your Honor. Christopher Off with the appellate, requesting 5 and 2.
Okay. All right. 5 and 2 and 4. And thank you, both of you. East Coast Custom versus New York City Department Consumer. Four and 1 and 5. GTV Media Group versus Confidential Global Investigations. Okay. Five and 2 and 5. Pan West Holdings versus Rockland.
Respondent requests 5.
5 and 2 and 5. Okay. Anthony DeBillis? 4 and 1 and 4. Cohen versus Getzel. 5 and 2 and 5 and 2. Gimbel versus Stu Leonard Jr.
Afternoon, for appellate, 5 and 2. For respondent, 5.
5 and 2 and 5. Thank you, gentlemen. PBA versus City of New York. Okay. And you are appellant for?
The PBA. And the rest of the
Say again?
We have 17 police unions. Mr. Engel's representing the PBA. I'm representing 16 others.
Okay, and how much time do you want?
5 and 5.
And you?
5 each month. 5 and 5.
Okay. All right. 9 and 2, 5 and 5. Jamie versus City of New York is submitted. Shire versus Shire is submitted. First case on the calendar, People versus Sharif Moses. I'm sorry, I missed one. Rusick versus Structure Tone. Now, I know we have a lot of parties, okay? And you realize, gentlemen, ladies and gentlemen, that you have 15 and 15 tops. So have you spoken with each other to figure out the time that we can allot amongst the 5 of you? Only 15 and 15, so you've got to tell me how you want the split. Tell me who you're here for.
I'm the defendant, respondent for CBRE, and I'll do 4 and 2. That's okay?
Let's see if the numbers work out. 4 and 2, who's next? Okay. Okay. Wait, aren't you here for Structure Tone? CBRE, I'm sorry. All right. Go ahead. And you? Aval? Okay.
Good afternoon, Judge. Respondent Plaintiff Philip Rusich. 5 minutes.
How much?
5.
Okay. All right, let's do. We're going to argue everything together, okay? All right. So plaintiff, 4 and 2, CBRE, 4 and 2, ST, 4 and 2, PNT, 3 and 2, AVAL, 3 and 2. I may be a little off on my numbers, but that's what we're doing, okay? 4 and 2. I thought you shortchanged yourself. Okay. I'm sorry? 3 and 2. Okay? All right. And then, so we're done. First case on the calendar, People versus Sharif Moses. You may proceed, counsel.
Thank you. Good afternoon, Your Honors. May it please the court. On behalf of Mr. Moses, Zoe Root. Your Honors, while the facts of the underlying case are admittedly quite complex, the request I am making today on behalf of Mr. Moses is quite simple. We're asking that you grant Mr. Moses the opportunity to have a 440 hearing. Mr. Moses's pro se 440 motion did all that a motion needs to do to warrant a hearing, which is raise an issue of fact as to whether his attorney's omissions in this case were the result of neglect, resulting in his deprivation of effective assistance of counsel. To warrant a 440-10 hearing, The movement need only establish that
Well, we're aware of this standard, but so let's talk about it as it relates to this particular case. So the defense that was put on by your client was essentially that he wasn't present at the time anything happened. He wasn't even on the floor where the incident happened, correct?
that's correct.
All right, so how could that be consistent with the request for an affirmative defense on felony murder that he didn't know that the person he was with had an intention or an ability to otherwise shoot somebody? Isn't that inconsistent? And if it's inconsistent, then how can that be ineffective assistance of counsel?
That's a good question, Judge.
Thanks.
So
that.
it's not necessarily inconsistent in that the request for an affirmative defense charge from the judge, the charge itself would have been read by the judge to the jury. And therefore, the defense counsel wouldn't have had to get up and talk out of both sides of his mouth, as you seem to be suggesting. In fact, he could put on the defense he had and request that if the jury credited all of the testimony that the prosecution's star witness had presented, which included that our client knew that there was a gun but thought that it wasn't loaded.
Are you suggesting that you should give an instruction to a jury that's not supported by the evidence at the trial? Because if defense counsel didn't support that affirmative defense, nor did the people, so what would be the evidentiary basis at trial that would permit that jury charge to be allowed?
Well, the people's own evidence did support that affirmative defense because the star witness said that our client was present, that he knew there was a gun, but that he didn't know it was loaded, which in and of itself is an affirmative defense to felony murder. Which
How could he know what he knew other than through hearsay? Right? So only the defendant could have said, I didn't know that the gun was loaded. Is there evidence in the record that establishes that he would not have known that?
Yes, there is evidence in the record that there was a discussion that there were no bullets in the gun, which would suggest that our client...
Again, that's hearsay unless you actually check the gun, right? You can only claim there was no bullets in the gun if you actually check the gun in the chamber.
Yes.
Anything else, that statement is a hearsay statement. And so this witness's belief in that hearsay statement doesn't change it from being hearsay, does it?
It doesn't change it from being hearsay, but it does impact whether or not a jury could have credited an affirmative defense, and brings it back to the ultimate question in this case is whether Mr. Moses established a question of fact as to whether or not he was given effective assistance of counsel, and whether, as a result, he should have received a 440 hearing so that all of this could have been hashed out in front of a judge.
May I ask
Go ahead,
another
of course.
question? But here's the question. It's like the attorney had to make a strategic decision here about whether requesting the defense, even if it did have some support in the record, would cut down on his principal defense, which is that the defendant wasn't there. And if it's an inherently strategic decision, tactical decision, doesn't that take it out of the realm of ineffective assistance? It wasn't a mistake, it was a judgment call.
It does, but the issue here is that we don't know that it was a strategic call. There is no evidence in the record to suggest whether it was strategic or whether it was negligence. And all we're asking for is a hearing to determine whether it was one or the other.
Thank you. You'll have time on rebuttal. You may proceed.
Your Honors, and may it please the Court, Anna Nachik for the people. The court below providently exercised its discretion in denying defendant's 440-10 motion. Specifically, as to the affirmative defense claim, there are at least two strategic reasons discernible further from the record as to why counsel would not have requested that charge. Specifically, that it contravened the defense's entire theory of the case, which was that defendant was not involved in the robbery, and second, defendant was not entitled to that charge to begin with. Additionally, as to defendant's claims regarding counsel's representation at the suppression hearing, this court has already deemed that the lineup was not unduly suggestive, and because of that, defendant resorts to rank speculation in his motion papers.
Well, can we get to the affirmative defense? You heard your adversary say that there was evidence in the record in the nature of your star witness, the co-defendant here, saying that he knew that the defendant did not believe that there was, that the gun was loaded. Is that in the record?
Your Honor, what is in the record is that defendant told co-defendant to check the chamber of the gun to make sure there was not a bullet in the chamber of the gun. Willie Jordan did testify to that. However, Willie Jordan testified later on that that didn't necessarily mean that the gun was empty. It just meant that there was not a gun in the chamber. There could have still been a gun in the magazine, which is where the bullet, or there could have still been a bullet in the magazine, which is where the bullets are kept within the gun. Additionally, even if defendant was entitled to this affirmative defense, it was not ineffective assistance of counsel not to request it. The Court of Appeals has held that the failure to request an affirmative defense alone does not constitute ineffective assistance of counsel in and of itself. And if there are no further questions, we ask that you affirm.
Thank you. You may proceed.
Your Honors, I'll keep my rebuttal brief, which is that the nature of the questions that we've explored in this argument have brought us back to the very crux of my argument, which is a question exists as to whether Mr. Moses was deprived of effective assistance of counsel, and because that question is still open, a hearing is necessary to determine whether or not he was deprived of that right. Given the totality of the circumstances, including that Mr. Moses wrote his underlying motion as a pro se litigant arguing two complex legal issues while serving 25 years of incarceration, his modest request to have a 440 hearing should be granted. Thank you.
Thank you. Lettieri versus Port Authority of New York and New Jersey.
Good afternoon, Your Honors.
Good afternoon.
Mindy Callis for the defendant appellant, Port Authority of New York and New Jersey. We're seeking reversal of the grant of summary judgment that was entered in the plaintiff's favor in connection with the plaintiff's labor law, section 240, subsection 1 claim. The testimony that plaintiff gave at his deposition establishes that he was the sole proximate cause of the events that ensued. He'd been an elevator and escalator mechanic for 17 years. On the date of the injury, he was working in a space that was between two escalators. In order to die,
Was he told to wear a harness?
he wasn't told specifically with respect to this task, but he testified that he knew that harnesses were available, and he made the conscious decision not to use a safety device.
Did he say he had a harness that he was given, was it 17 years before?
I'm sorry, I didn't
Did
understand.
he say that he had a harness which he had been given, was it 17 years before?
No, he said that his employer supplied him with safety devices, including...
17 years earlier. That's
No.
what the record shows. That's exactly what the record says.
Your Honor, if you'd like to point me in the direction of...
No, that's not my job.
But, so the record at pages 89 to 90 states...
But
that
anyhow,
his-
no one told him
his
that day.
employer-
No one told
Counsel,
him that day to wear a harness. Am I correct about
Right,
that?
you are correct. No one counseled him that
One
day.
other question. There were no tie-offs in this crawl space, were they, for a harness?
There was no... There were no types because he wasn't using a harness.
No,
No, that's not what I asked.
No.
Thanks. That's not what I asked. You can't use a harness unless there are tie-offs, right? That's how they work, right? You go, then you move, right? You have to tie it off.
Okay.
Were there places in the crawl space to tie off?
I don't have the answer to that question as I stand.
Then the issue of the harness is irrelevant, because it is only relevant that he didn't use a harness if he had a place to tie off. If he didn't have a place to tie off, then the harness is irrelevant. Because you can wear it, but if you can't tie off to something, it is of no purpose.
But even more relevant is the fact that he determined after
Counsel,
years.
I need you to hear what I'm saying.
Your Honor, I'm
Right, so
listening.
if there's no, unless you can say and point to us in the record, right, where in the record it says that there were places to tie off, that one he was aware of, that two existed, and that then three he ignored. I don't have any of that in the record.
What you do have in the record is his testimony that he, using the crawl space for over years of time, had determined that he did not need any safety devices in connection with his work.
Well, does that make him a sole proximate cause, that determination?
Well, it's not.
What were the safety devices that were offered by his employer or others in order for him to use there, that could be used?
His conclusion, which he testified to very explicitly, was that he didn't think that the conditions were
That wasn't the question.
safe.
That's not the question my colleague just asked you. What devices were missing, right? What was he supposed to use? What was available for him to use as a safety device in this crawl space? He didn't even have light.
Well, he used a flashlight. I mean, that's what he
That he held, that according to the record, he had to hold in his mouth.
Well,
Doesn't sound safe to me.
so with respect to how safe the situation was, this is a person who's testified that he didn't believe that he needed to use any safety devices. So when you're,
Your time is about to run out, so let me just ask you, you raise on appeal the issue that this is routine maintenance, but you didn't raise that issue below, or at least didn't pursue it below, am I correct?
so it wasn't pursued below by trial counsel, but it is evident from the face of the record.
But it wasn't,
No, it wasn't argued.
I mean, you also raised the issue which you haven't pursued on appeal, that the Port Authority is not subject to the labor law.
Right, we determined not to pursue that argument on appeal.
Thank you. You'll have time on rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the Court. Michael Zhu, Appellate Counsel, the Schwartz-Appel attorneys of record for the plaintiff respondent. I think the panel got the gist of the defendant's argument here, and that the trial court's decision should be affirmed, because what the defendants are advocating here is that the plaintiff's own determination that he didn't need a harness was the sole proximate cause is really flipping the burdens in reverse, because it's the burden on the owner and general contractor.
Let me turn your attention to the last thing your colleague was speaking about. Is whether this is routine maintenance or not something which is apparent from the face of the record?
No, it's not, because in order for them to raise that issue, they would involve new facts that were not discussed below. And because the arguments were not raised below, plaintiff never had an opportunity to address them. But even if it was reviewed here, I would say that it's not routine maintenance and it's a repair, because the plaintiff's testimony is he was called that day to Terminal 8 to check on a noise issue with the escalator. This isn't something that's done routinely. There's no testimony that this was done routinely. There's no testimony that this is part of his usual maintenance issue. The only testimony is that he was told by Nick to go and check on this noise issue. He crawled up the escalator and investigated it. This court 2 years ago in Keogh versus 61 Broadway held exactly the same thing in a fact pattern that was almost similar. There, the plaintiff is an elevator mechanic. He was called to 61 Broadway to investigate a noise complaint that was startling passengers in the passenger elevator. In the course of that investigation, he climbs down a set of a permanently affixed ladder and he falls. And although I didn't get 240 on that one, you held that this was not a routine maintenance issue, but a repair because of the nature of the work, and that the testimony there was that he was there to respond to a complaint of noise, which is the same exact thing that happened here with Mr. Lettieri. So based on his testimony, even if you want to reach the issue, which is unpreserved, I would say that you would have to find that this was a repair and not routine maintenance.
Getting back to the sole proximate cause, in terms of your understanding of what the law would be with respect to that, the plaintiff's refusal or decision not to use a safety device could be the sole proximate cause if he had been instructed by his employer or someone in charge to use a safety device. Do you agree with that statement of law?
Absolutely, Your Honor.
But to your knowledge, is there anything in the record in which he was instructed with respect to this task or any task involving him going into the crawl space not to use a specific safety device that he ignored?
2 points in response to that. One, there's no testimony that a harness was available. 2, at page 121 of the record, I believe page 8 through 10, he states that he was asked whether Nick or anyone else told him to wear a harness, and his answer was no. And that's at page 121 of the record. So the fact that he decided for himself that he didn't need one is irrelevant because it's the owner and general contractor that has to provide him with one. But they have to provide, they have to actually give him one.
They may have agreed with him that it didn't require a safety device, in which case he couldn't be the sole proximate cause because they'd be a proximate cause as well, right?
Exactly. It would be conceptually...
That's the rationale behind that.
Right. It's conceptually impossible for his conduct to be the sole proximate cause when they don't even provide him with the safety device to begin with. Unless...
And did I miss anything in the record? Was there any proof that there was someplace to tie off?
No. You're correct, Judge Gonzalez. There's no testimony at all as to whether there were any tie-offs.
Okay, thank you.
Thank you.
Counsel, you have time on rebuttal.
First, with respect to the case that was cited by the respondent, Keogh. Keogh is a case where a mechanic worked on cables in an elevator over several weeks of time. The deposition testimony in this case that the plaintiff gave described multiple occasions when he was called to fix matters relating to this escalator. So the time frame in Keogh...
Doesn't this confirm that this is a factual issue which we can't address then anyway on appeal since it's unpreserved? We have to be looking at factual testimony to resolve one way or another the issue.
So either the court determines that there is proximate cause, sole proximate cause or not, and then in connection with that finding, the court also has to consider what the testimony actually shows, which in this case shows that he routinely and for short periods of time used the crawl space to try to fix matters relating to the escalator. And one other issue that I would like the court to keep in mind is that it's the underside of the escalator that he's ascending and then descending. As he was descending the slope, he fell. This isn't a case where there was a failure to provide a ladder or a stairwell. This is a failure to provide a harness. On appeal, he also argues...
You keep saying that. And nowhere in this record is it established anywhere that a harness would have been an appropriate safety device here. Nowhere.
I mean, I understand your point,
Okay.
Your Honor. And so really all I want to do is distinguish Keogh on the routine maintenance issue and point out that he was not ascending a ramp, but the structure of the escalator.
Thank
Thank you.
Steinway versus Jaspin Schlesinger. You may proceed.
Good morning, Your Honors. Chris Burloff on behalf of the appellant Al Rose Steinway. May it please the court. We are here to address this negligent legal malpractice claim, specifically to point out the factual issues and the error that the lower court engaged in granting the motion to dismiss in this particular case.
Let me ask you, Mr. Rosenberg, who's principal or the agent of plaintiff, he signs an amendment to the lease, which creates this problem for him, doesn't he?
Correct.
So your point, I understand, as well, he was counseled by defendants to do this, or he should have been told, don't you dare sign that. But the fact is that he could read that amendment, and he signs it, and doesn't he then go and send it on himself to defendant's counsel? Why doesn't that knock out his legal malpractice claim?
Well, Your Honor, because the important aspect here is not that he signed it. That's why we're here, is because it was ultimately signed. It's the reason behind him signing it, which is the affirmative advice that was incorrect and erroneous that was provided by his counsel, Mr. Epstein, at the time. This is not like the cases that are cited by the Jaspin firm in this case, which rely largely on the lack of an explanation. Whereas here, we're not just relying on a lack of an explanation. We believe that would still be legal malpractice, but we're relying on the affirmative statements that this was just mere housekeeping. You weren't giving up anything substantive. That distinguishes this. So at the end of the day—
There's no email that verifies that statement, is there?
No, Your Honor.
This is an alleged oral statement that your client says the attorney said to him, which the attorney denies.
Your Honor, I would agree that it is—
Am I correct on that?
Yes.
Okay.
But I would—
Now, what I want to understand is how Mr. Rosenberg, who is a seasoned businessman in the field of real estate, you're telling me he didn't understand the plain language of this statement, of this modification that he signed? He didn't understand it? It's as plain language. It's really— there's not a bunch of legalese. It is really simple to understand. So I am at a loss for this claim that he was completely surprised by the outcome here.
Your Honor, the standard in terms of examining plain language would come into play and be more of more import here if the basis was the failure to explain. That's not the reliance here. The argument here is that the language may have said what it was, but Mr. Rosenberg was relying on the affirmative advice of counsel, saying that there was nothing.
Did your client say he didn't read this statement before he signed it?
No.
Okay, so I am assuming he read it, and that because it was in plain English, he understood what it meant. He knows what an option to buy is. This is not a complicated concept, right? I have the right to buy up until this date. This isn't rocket science here. So I am at a loss for this claim that he wasn't properly counseled, that he didn't understand, based on this statement, which is just his allegation, because there's no proof that that statement was made anywhere.
If I may, I disagree with that last point, Your Honor. There is proof that the statement was made by the affirmative testimony of Akiva Cohen, who is a third-party attorney who spoke with the defendant, Mr. Epstein. So that's at the record at 1571 to 72 of Mr. Cohen's testimony. Additionally, that is demonstrated by the malpractice notice that is at issue in this case on the record at 1594 to 96. So all of that combined with Mr. Rosenberg's testimony does demonstrate that the statement was made at least to create factual issues.
Can I ask you something? Under the original agreement, the original owners of the building were free at any point in time to sell this building, correct?
Yes.
Okay, so that the option to buy in 2023 did not prevent the owners of this building from selling prior to 2023 at any point. Am I correct?
Yes and no, Your Honor.
What yes and no?
Actually, no, but effectively, yes, because it wouldn't have made sense for them to sell because...
No. Forget whether it makes sense. I want to know whether contractually there was anything in that original agreement that prohibited them from selling this building prior to 2023. And I understand that there was a provision for right of first refusal. I'm not talking about that. What I am asking is, was there any provision in the original contract that prevented the owners of this building from selling prior to 2023?
No.
Which means that if at any point prior to 2023 they found a buyer, the only remedy your client had was reliance on the right of first refusal, the same place he was in after signing this modification, correct?
No, Your Honor.
Okay.
With respect to that, the option survived the sale. That's the important thing here, is so if prior to this amendment, the property was sold for whatever price, 15 million, 20 million, the option survived such that he could purchase the property for 11.4 million at the most in 2023. So that's why...
Did the option say you have an option to buy in 2023 from whomever is the owner?
It was a survivable right, yes.
Okay.
It survived the sale. So, Your Honor, that's why
You'll have time on rebuttal. I needed an answer to that question, and you gave it to me. Thank you.
Thank you, Judge.
You'll have time on rebuttal. Counsel.
Good afternoon, Your Honors. May it please the court. My name is Marion Rice, and I represent the defendant attorneys.
Can I ask you a different question than we've been exploring, which is that the trial court said that one of the reasons you got summary judgment is because the damages were speculative, right?
Correct, Your Honor.
All right, so let's talk about why these damages would be speculative. The question of figuring out damages would be calculating what the value of that option in the lease was that was given up with the modification, correct?
Correct.
And so the option was phrased so that it was contingent upon the plaintiff not being, or the tenant not being in default under the lease, right?
That's correct, Your Honor.
Right, and the court thought that that was speculative. The court also thought it was speculative to the extent that we wouldn't know if years hence that the tenant would be in a position to otherwise financially purchase the option, right? That was part of it too.
That was definitely part of it.
So here's my question, because I looked at these provisions in an option to buy at the end of the lease, and I'm like, well, these are pretty standard conditions, correct? You find them in almost, I would say, probably 100%, if not close to 100% of leases that have an option to purchase at the end. Right? It's pretty common, right?
Except for two things. Number one, this option was not assignable, so you had to make it to year 2024 in order to do it. And number two...
But that's always the case in every lease. In every lease, you have to get to the end of the lease and not be in default at the time the lease terminates. I mean, those are very common circumstances to otherwise exercise an option that exists at the end of the lease to buy at the conclusion of a lease. It's standard.
Correct,
Isn't
but
it?
Judge Maisley took
So
into...
now, wait.
I'm sorry.
These are my questions. Okay.
Sorry.
So if in fact that makes it speculative, then are you arguing, and is it an appropriate conclusion that an option to purchase at the end of a lease that has those kind of standard conditions can never be valued because it's speculative? Or does it have value?
That would not be what I would argue, Your Honor.
Okay, so tell me why is this different than the standard situation where somebody has that right at the end of a lease? Isn't it calculable?
Because we were dealing with the facts that were presented at the time that this was going on. At the time that this was going on, Mr. Rosenberg had multi-million dollars of judgments personally against him. He was a subject of a $16 million adversary proceeding in the bankruptcy court. He had entered into a tentative $9.2 million settlement with the bankruptcy court. He owed $22 million in back federal and state taxes that were warrants and liens against him personally. He went into the state court when, in fact, he did sue the landlord and testified before that court that he had no assets.
But counsel, didn't he in fact come up with the money to exercise the right of first refusal, which was an even greater amount?
He brought on a partner and did do that.
So he could have done that the same thing in 2022. Why is that speculative?
Because as Judge Maisley found, you can't tell what the circumstances are going to be in 2022.
But we know
Yes,
he did it years earlier. Isn't that pretty good evidence that he could prove he could have done the same thing when the time came to exercise his right?
Not necessarily, Judge. You can't put the same facts that were there. I mean, Mr. Rosenberg was in default. From the day that he entered the ground lease in 2014 up until November of 2015 and December of 2015, he was not able to pay his rent on time.
Did he exercise the right of first refusal?
But you didn't have to be, you could be in default and exercise the right of first refusal. You did not have to be in default. That's the difference between the provisions. In order to exercise the option, he had to be free from default. The right of first refusal did not have that in that.
But let's just step back a moment. I mean, how does Epstein allow Rosenberg to contemplate? The reason for this amendment is in order to procure consent to a lease assignment. And if you're doing that, you would have the two things running simultaneously. Look, we're going to give you we're going to sign the amendment. You're going to give us the consent. And here it's, well, you sign the amendment, give away these valuable rights, and it's going to take care of your problem. But certainly Epstein had to know, and Rosenberg probably had to know it too. You needed that in writing. You needed something signed and subscribed. And
that is
how does Epstein allow that to go on without obtaining something tying down the consent to the assignment?
He did. That's exactly what he did. On December 30th, he wrote to Mr. Rosenberg, he said, are you going to sign?
Then why did they end up in court over that?
I can finish it. The reason they ended up in court over it is, though, even though Mr. Epstein sent to the landlord's attorney, I want a recognition agreement before you get the lease amendment. Here's the recognition agreement. My client agrees to the form of the lease. We can tie them up both together when we get the recognition agreement. He sends that to the landlord's attorney on December 30th. The landlord's attorney responds that same day saying, okay, I'll take care of it on Monday morning. What happens, though, is Monday morning, nothing happens. And why is that? Because on December 28th, Mr. Rosenberg, without telling Mr. Epstein, sent the signed amendment directly to the landlord.
Well, what do you do with the fact that in your letter to the malpractice carrier, you recognize that you didn't understand the terms of this amendment?
The letter is not from Mr. Epstein. The letter is a draft document that was sent to him.
It's a draft of general counsel of the firm, right?
Correct, and it was sent by the general counsel to Mr. Epstein for his comment. Mr. Epstein testified the content of the draft letter was false.
Yeah, but all that does is create an issue of fact. Why do you get summary judgment on
It's after the
that?
fact. It's not what happened contemporaneously. What we have contemporaneously is a series of emails over a 4-month period of time where everybody held this document in their hands, this document that had the word unaffected crossed off and the word void written. It was clear as day. What happened after the fact can't create a question of fact with respect to what was going on at the period of time, and that's what Justice Maisley found. She found that the record amply reflected what the parties knew at that time, that there was constant discussion using the lease amendment as a chip as a bargaining leverage. And the only reason it did not get used for that is because, unbeknownst to Jaspin, Mr. Rosenberg sent it directly to them and did not tell us. We didn't learn that until after the litigation was in discovery. Mr. Rosenberg, at his deposition, denied it. Mr. Rosenberg said that Mr. Epstein had sent it to the landlord. Mr. Epstein never knew until discovery what had happened.
Thank you.
By the way, Mr. Epstein concedes that he provided Mr. Pasoltina with information for that led to the malpractice carrier. Is that so?
There's nothing in the record that says that.
Thank you. You have 2 minutes on rebuttal.
Thank you, Your Honor. With respect to the clarity
So
of the
why don't
language.
you pick up on the point of why is Mr. Rosenberg sending that letter out ahead of time on December 28th?
Because
The
he was
amendment.
because he was advised to sign it by counsel, that's why. Whether he sent it directly to the...
Except he himself was concerned about getting something for it, right? He refused to sign it earlier because he wanted a commitment that the subtenant by the landlord would be approved. So why would he send it without having that firm approval of the subtenant?
Your Honor, that would be relevant if our damages were based on the lack of receiving the quid pro quo, but that's not what our damages are based on. Our damages are based on the affirmative negligence in advising him to sign the amendment and the lost option.
Except that the very reason, you can't just decide unilaterally, I'm going to ignore that part of it. That doesn't have anything to do with it. That was why he didn't sign it initially.
It may be why he didn't sign it initially.
So it had everything to do. It is not, you can't excise it from this analysis.
Except that the quid pro quo only demonstrates that something was being negotiated, not what was being negotiated.
That's precisely what was being negotiated. He wanted the subtenant approved because he already lost one subtenant prior to this, right?
Yes, Your Honor.
Okay. And so in his mind, it seemed from the papers that the only reason to entertain signing this new amendment was in order to get the approval on the subtenant so he could start making money on his lease.
That's correct. But, Your Honor, that doesn't necessarily indicate what the amendment is for, and that's why we're referencing this court's cases.
But wait a minute. If there had been a quid pro quo that had been executed simultaneously with the amendment that otherwise gave up some rights with respect to exercising the option to purchase, you wouldn't have a claim for malpractice, would you?
Yes, we would, Your Honor.
You would.
Yes, the reason is because the quid pro quo was intended to be a housekeeping right for a right that we believed we already had under the contract because they couldn't withhold consent except under certain bases.
Yeah, but it's easier to get consent in hand than have to litigate it with somebody. I mean, honestly, your client understood that as a businessman in the commercial real estate world, right?
Yes, but it's further evidenced, Your Honor, by the fact that before that December timeframe, Mr. Epstein did nothing to obtain the quid pro quo either, but he still affirmatively advised his client to sign the amendment. The clarity of language isn't relevant when you look at that affirmative advisement. So
Thank you.
Thank you, Judge.
Thank you. East Coast Customs versus New York City Department of Consumer. You may proceed.
Good afternoon, Mackenzie Fillo for the Department of Consumer and Worker Protection. This court should reverse because Supreme Court made a fundamental error in looking at this case as if it were just about insurance. This case is about a business's failure to be honest with its regulator. The administrative code expressly authorizes the department to revoke a tow truck license for false or misleading statements in connection with an application, and it is undisputed that that's exactly what
Are
happened.
you required to have some sort of evidentiary hearing before that can happen?
No, not at all. And some statutes give licensed entities the right to a hearing. This one does not. It says
Like
notice.
administrative code, why wouldn't administrative code, which has such a provision, does it not? Administrative
It's
code
20-504.
E1.
I apologize.
Well, you had the right section. Why wouldn't that apply here?
It does apply here. It says after due notice and opportunity to be heard. Now, some statutes say notice and hearing. This court in the Flag case that we cited in our brief expressly distinguished those two.
So why don't you compare Administrative Code 20-504 and Administrative Code 20-104E1?
Yes, the 104, or whatever the number is, the earlier number, is a general powers statute that just talks about the department's commissioner's powers generally, whereas 2504 is specifically about tow truck licenses. So the specific statute governs over the more general statute. Moreover, even the earlier statute, I believe, says something like, and this is in addition to all the other powers that the commissioner has. It's not supposed to be limiting, it's supposed to be expansive.
So am I right that if this were a case solely about the rates of insurance, then the structure that is set up in the statute with respect to the fines that can be imposed is one rubric of penalty?
Right.
But here, we have two allegations, not just that it was inappropriate levels of insurance, but that they failed to notify the agency of a change in the insurance. And it is that violation that permits a suspension of the license.
It's not just that. It's they also submitted a fake certificate of insurance. They were misleading the department. It's about honesty. It's certainly rational for the Department of Consumer Protection to expect the businesses that it regulates to be honest with it. Sometimes people do submit an application that indicates they do not have the required insurance. And in those cases, the department tells them, hey, actually, here's our required insurance. And then people have the right to fix it. It's not about not having the insurance. It's about lying about what insurance they have.
Right, here in the renewal, they actually represented they had the right rates of insurance, and it apparently appeared that they did. And then after they got the renewal, they went and decreased the amounts.
Exactly, they raised it right before.
They don't even dispute that that's what happened. They lay it off on their insurance agent.
Exactly.
But the reality of it is that ultimately they were underinsured and they misrepresented on the renewal application that they were appropriately insured for the relevant period.
That's exactly right, yes. It's about honesty, not about insurance.
Thank you.
Thank you.
Good afternoon. May it please the court, David House for the respondents. Your Honors, it's undisputed that the petitioners here were granted a license. They have a vested property interest in that license because it is necessary in the pursuit of their business. And the case.
What about the fact of the dishonesty that they misrepresented what insurance they had? And there's no dispute that they misrepresented the insurance they had. Why should they be able to?
But Your Honor, that's
keep
part
the
of the.
license when they openly lied.
Sorry. That's part of the problem here, right? There was no hearing at which this could be fleshed out.
What about the provision cited by counsel 2104E1, which says due notice and an opportunity to be heard? That doesn't say anything about a hearing.
Well, respectfully.
There was an opportunity to be heard. They had an opportunity to go and present evidence. Why isn't that sufficient?
Respectfully, it's our position that 2104 and 2504 should be read together. 2104 requires a hearing, and 2504 says notice and opportunity to be heard. The case law is legion.
Those are two separate things. Those are two separate sections. And explain to me, what is it that a hearing would have uncovered that papers and an affidavit could not have revealed?
Well, in direct response to that, Your Honor, I would say that the petitioners are not required to demonstrate a meritorious defense.
Counsel, look, you can't come here and say, oh, we are so offended, we didn't have an opportunity to be heard, we didn't have a hearing, and then not be prepared to tell this court what you would bring to the table if there were a hearing. What defenses could your client put forth to having modified the insurance and not notified the agency?
Because there was the expediter. They had hired somebody, so it's different than it might be considered a misrepresentation, but it's not a willful misrepresentation.
An expediter provides an agency the information provided by their client, no? Or do they pull it out of air?
Mr. Vargas testified that, or stated anyway at the meeting, that he didn't sign it, that he talked to the expediter, but the expediter filed the application without his review.
Counsel, can we agree that an expediter has no personal knowledge of a business's function, that they take the information given by a client and then produce it at whatever agency that they are hired to expedite it at? Am I correct about that?
I don't mean to be, I don't know, honestly, Your Honor. I don't know.
Really?
I would assume the function of an expediter is familiar with the business of.
Why? Why would you assume that? And what evidence do we have in the record that that is the case, that I should accept that argument?
It's not in the record.
Okay.
But I would just like to take a step back for a moment. If they know that they are going to have a hearing, then they.
Who's they?
Excuse me, the petitioners, if they're notified properly that they're going to have a hearing, they may present.
There's no, wait.
Can I ask it maybe a different way?
Please.
What would the respondents have put in their application that the expediter did not? What would they have truthfully told the agency that the expediter did not at the time of the renewal? What was false in that right now? You know,
I'm not disputing that they may have maintained incorrect insurance amounts, but there's a difference between.
Wait. This is a little something different, right? They wouldn't have done anything different. The expediter said they have $1 million worth of insurance, and your client wouldn't have said anything different, right? The problem, isn't the problem that immediately thereafter, your client then reduced the insurance to $300,000?
According to what he stated at the meeting was that he spoke to his broker and said, look, I can't afford this anymore. It's killing me. I need you to reduce our rates. So
yeah, but that's not a defense to not maintaining insurance.
It's not a defense to not maintaining insurance, but it is a defense to it being a willfulness finding. And if you have a full hearing.
Are you kidding me? I can't afford it. Is not an option in the statute.
But he never told.
You get $1 million worth of insurance unless you can afford it. That's not what the statute says, right?
But that's correct, Your Honor, but it's not what he said. He said that he said lower my rates, but he never told them lower them below what the legally required rate is.
How could you get lower rates for the same level of insurance? I mean, that makes no sense, right?
Well,
nobody gets that. He's a businessman. I don't understand. You get what you pay for.
Well, I think he spoke to his broker and he said, look, can you get me, I need to reduce my rates. And so the broker said, yeah,
I'll do that for you, and you'll get $300,000, right? Which is significant in terms of the business that your client runs, because he's a tow truck operator, and it's important that they otherwise maintain the right amounts of insurance given the likelihood of risk of accidents in their business. That's a statement, not a question. Okay.
Thank you so much.
Thank you.
Counsel, you have 1 minute.
Different companies.
Thank you. I would just like to note that, first of all, this argument about the hearing is unpreserved. They came to this meeting with a lawyer. The lawyer never said we want a hearing before oath. They never asked for some different penalty to be applied. They never asked for this penalty schedule. They never asked for a fine. All of this is completely unpreserved. But I'd also note that willfulness is not an element of the statute. The department did not have to prove that they acted willfully. But I would also finally note that on page 811 of the record, the transcript of the meeting, the petitioner was asked, did you give him permission or authority to reduce the rate down to what, 300,000? I might have, honestly. he did ask his insurance guy to reduce the insurance rate below the required amount.
Thank you.
Thank you.
GTV Media Group versus Confidential. You may proceed.
Your Honors, may it please the Court, Jesse Klinger for Petitioner Appellant GTV. The lower court's decision should be reversed for two reasons. First, the lower court abused its discretion when it refused to grant a default judgment against DW News, despite the fact that DW News failed to appear after being properly served, and the lower court...
Would you still, even though they were quote-unquote default, you would still have to have a meritorious claim against them, at least prima facie, right?
I think we have those claims, Your Honor.
Maybe so, but that's sort of underlying the argument to reverse as to the appearing defendant, and so they kind of go hand in hand. And I guess this is my way of encouraging you to not treat these separately, not just say they didn't appear, we should have gotten a default, but let's get to the merits of your claim that you were entitled to pre-action discovery.
Thank you, Your Honor. The arguments that apply to CGI
So how do you show that you have a cause of action if you knew who the source was, and that it would be a meritorious cause of action?
We have a cause of action for breach of fiduciary duty and breach of contract against the fiduciary who leaked the information. We also have a claim for aiding and abetting those breaches, the breach of fiduciary duty.
But the person you want to turn over the information says he or she got it from a public blog.
So the CGI source, we've only heard from the CGI on this. So we don't have anybody making statements based on personal knowledge. There's many discrepancies in what the source said.
Say that again, I didn't understand that.
Sorry, so the CGI is the only one stating where the source got the information from. We have no statements from the source directly in the court.
Well, I didn't understand it that way. What I understood is that the source said, look at the blog, and they looked at the blog, and the blog was certainly a public source, and so we have that problem. We don't have somebody identified, nor let me step back. I think part of the problem in this, and part of the problem I was having with this, is that because the information seemed to go through hands other than internal hands within the corporation. I mean, after all, it's admitted the information was given over to the SEC. And while it may have been confidential, we don't know where along that avenue that there may or may not have been a breach. So how do you, other than through your speculation, conclude that the source of the information must, and I put that in quotation marks, must have been some fiduciary within the organization?
So on that point, Your Honor, there were only a limited number of people who had access to this information. It was the fiduciaries, and it was the government agency that had the information.
And we don't know if there were breaches or leaks along the way as it was otherwise winding its way from your client to the SEC.
It went through counsel, and now those are fiduciaries. So it went from...
And we don't know whether the SEC, maybe somebody in the SEC leaked it, in which case you don't have a claim there against a fiduciary. They're not your fiduciaries. May be wrong for them to do that, but you don't have a claim against them. You have a contractual claim or fiduciary claim.
I mean, once it goes to the SEC, well, of course it would be wrong for it to be done, but there are a whole bunch of people who could have leaked it.
On the prima facie case, the petitioners are entitled to the benefit of favorable inferences of the facts alleged.
Yes, but you're saying those favorable inferences permit you to go basically on a hog wild fishing expedition to anyone you want to put in a chair and question.
Respectfully, Your Honor.
And our case law has been very clear that you have to proffer a basis for discovery, not just, I think it must be. There's got to be more than it must be.
Yeah. Respectfully, Your Honor, there is more than it must be here. This is not a fishing expedition. We're seeking
What's
targeted.
the more than must be?
So we're seeking targeted discovery from entities that had highly confidential business information.
Counsel, but again, there is no basis, there's no information that I see in this record that would point to any particular entity that you are seeking discovery from that showed that there was a breach there.
Your Honor, the source that sent the information to CGI initially sent a photo of an image, did not send the blog post. The blog post comes 3 months later. All the forensic investigation shows that there's a discrepancy, that the blog post and the image of the blog post has a date that's in January, well after the discovery requests were served, well after the claim was initially made to CGI that they had gotten this information from the source. So there's really a concern here and many discrepancies about whether or not the source actually got the information from the website. And because petitioners are entitled to the benefit of favorable inferences regarding its prima facie case, and the investigator looked to see if there's a security breach, I don't believe that the speculation that someone from the SEC might have leaked the information is enough here.
I agree with you that the speculation is not enough. You have time.
Thank you.
Good afternoon, Your Honors, and may it please the Court. I'm Amiad Kushner. I'm here on behalf of the respondent, Confidential Global Investigations, and I'll refer to it as CGI. Your Honors,
So in fact, the information that they're concerned about, and we'll call it a leak, it was information that was otherwise available to a controlled number of people, even if we take into account the SEC investigation, right?
well, that is their allegation. CGI has no personal knowledge of that, but that is their allegation. Your Honor, it's their burden to come forward in order to get pre-action discovery. They have to come forward with two things. One, a meritorious cause of action, and two, showing that the pre-action discovery they're seeking is material and necessary for them to assert that cause of action.
So we don't know if this information was leaked or it was hacked or how it came to be on the blog post.
Exactly.
And without that, at least something other than their suspicion that it must have been a leak, we don't know that there's a claim against an internal leaker, even if it's an unnamed internal leaker. Is that your argument?
That is our argument, and I would just put a finer point on it. You know, in order to assert a meritorious cause of action, what does that mean? You know, in the context of a claim for breach of contract or a claim for breach of fiduciary duty. Okay, who is the defendant? Which contract?
Well, they don't have to name a defendant. They're looking for the pre-action discovery in order to discover the name of a defendant. They may have to otherwise identify the category of who they believe is the defendant. Like, you know, they say it's somebody from within our organization, but don't they need something more than just saying we think it's from somebody in our organization?
You need a meritorious cause of action. What you can be missing, the element of the cause of action that you can be missing is the defendant. But you have to show that there's actually a cause of action. So you need to, for example, breach of fiduciary duty. Okay. Is it a breach of
But you agree, you don't need to name the exact defendant.
Right. But
you can get pre-action discovery on who the defendant is.
But you still need to show that there's a meritorious...
you need a claim.
You need a claim, whether it's fiduciary duty, breach of contract. The petition has no dates, no times, no specific allegations about how the alleged contractual or fiduciary duties were breached.
And we don't even know whether the leaker, and I put that in quotes also, whether that leaker is from CGI, from GTV, or from one of the banking institutions.
Exactly. And Your Honor, I would point out that on its face, the petition in paragraph 11, and this is page 15 of the record, it concedes that the allegation that the information was deliberately leaked by a fiduciary is made upon information and belief. So if the claim is made upon information and belief, by definition, it's not a meritorious cause of action. You can't just say, well, we're alleging contractual and fiduciary breaches upon information and belief, and therefore we're entitled to pre-action discovery based on that cause of action. We're not aware of a single case granting pre-action discovery based upon a cause of action that's asserted entirely upon information and belief, which is this case. It's pure speculation, it's supposition. They believe that there was a fiduciary breach, and that's basically it. You can't get pre-action discovery unless you actually show that there's a meritorious cause of action. That's different from believing that you have a cause of action.
Have they identified the universe of potential people within JTV who might have had the subject information at issue?
They have not.
So as to be able to say to the CGI employee, do you know these people, this list within JTV who would have had this information? Do you know any of these people? Were you provided with that list to test your own employee?
We were not provided with that list. The petition does not include that list. It's not on the record. It's an unknown universe of alleged fiduciaries, and there's absolutely no specificity around that, Your Honor.
Thank you. You have 1 minute, counsel.
Thank you, Your Honors. In rebuttal...
2 minutes, sorry, I was cheating you. Go ahead.
I appreciate it. To address some of your questions to my colleague, no banking institution had access to this information. The information was...
Wait. The information that was provided, wasn't it regarding 8 specific bank accounts and those bank account numbers? How is it not related to bank accounts?
There was also a check that was stored in a safe, and the information...
But that check is related to a particular account number.
Yeah, but I don't think it was all the same bank, so there wouldn't be one entity.
I didn't say it was one.
Right, so I guess, again, so just like on the SEC potential leaker, I would say the idea that the banking institutions got together, or one of them was able to...
Okay, did you provide a list of the potential people who were fiduciaries within GTV that would have had this information and could be potential suspects as being leakers? Were CGI provided that list so that their employee could look and see if they knew anyone on that list?
Not to my knowledge, but the discovery requests to CGI all went to, including any communication.
But don't you have an obligation before you bring this kind of application to do an investigation to otherwise make known certain facts that lead to a conclusion that it would have been somebody within your organization?
Yes, Your Honor, and we conducted that investigation. We hired a forensic investigator to look into whether or not there was a hack of our systems in order to determine whether or not that was the way in which the leak occurred. We then did an internal investigation where we spoke to our own employees and asked them questions relating to the leak. And the government agency was requested to see if to disclose any information if our confidential information was ever disclosed to third parties. So given the limited number of people who had access to this information, the fact that there are so many discrepancies with the source's claim that it got this information originally from the website, and the fact that the lower court made a flawed assumption that the only purpose of this petition was to seek information about people potentially from within the company, but we're also seeking information about people who aided and abetted those individuals who would also be potential defendants. So it was the flawed premise. Sorry.
But you are building speculation. It's like double hearsay on top of triple hearsay. So you don't know whether anyone in your organization was a leaker, but on top of that, you want CGI to be able to discern without knowing who the universe of potential people with the information at issue are, right? They should just tell me everybody you know and everybody who might potentially, I mean, it just seems like really broad and not at all narrow.
Understood, Your Honor. I would say that the identity of the source itself, who had the information, sent it to them initially, not with a link to the blog post, but with just a sheet of paper that was an image. The identity of that source is not a phishing expedition. It's someone who they claim was the originator of the information to them, and there's nothing in the record that establishes that the source actually got the information from the website, as opposed to being...
But there equally is nothing to establish that that was not the source.
I would say that our investigation, the lack of a leak, the limited number of people who had access to this information...
Well, we don't know what that is, though. So how can we assess it?
Sorry.
I don't know what the universe of people who had access to this information is.
Well, it's in the record that it was the attorneys who helped with the investigation and a limited number of officers.
Again, a limited number. What does that mean? 1, 2, 10, 20? That's a limited number.
It's not in the record, so I don't want to make it. But I would say that here, given that...
Do you know?
I don't know for sure, but there was a check...
Neither do we.
Sorry?
Neither do we.
Okay, but there was a check that was in a locked safe, and that account number showed up.
You told us
and
that.
There's not going to be a number of people. So the only plausible explanation is that whether intentionally or unintentionally, one of the fiduciaries leaked this information, and that the source is either one of those people or someone who aided and abetted them. And the number of discrepancies that deal with the date of the blog post and the fact that petitioners are entitled to the favorable inferences, I think means that the speculation about whether it could have been disclosed by the SEC or another banking institution is not sufficient to affirm the lower court's orders here.
Thank you.
Thank you, Your Honor.
Where am I? Penn West versus Rockland.
May it please the court, I'm Josh Katz, and I represent the appellant, Rockland MCA2 Holdings, LLC. There are...
So could the plaintiff have said to you, or taken the position, that had we known about this non-annual maintenance budget item, or had we known about this typographical survey, we could have refused to close under the provision of the contract which provides for the plaintiff not closing?
Well, let me take those separately because I think they really are two analytically distinct issues. There is absolutely nothing in the contract.
Yeah, because the non-annual maintenance clearly is something which comes up post-contract. It's a representation about 2020, and you've made representations financially only going to the end of 2019, or September 2019.
Right. That is correct. But beyond that, there's no allegation that we lied to them about the equipment. There's no allegation that we didn't let them inspect the equipment. There's no allegation that they didn't know that these items would need to be...
What remedy does the plaintiff have for whatever you did wrong in terms of the non-annual maintenance budget and your failure to turn over the survey, the typographical survey?
Does the plaintiff have what? I'm sorry, I didn't hear.
What remedy does the plaintiff have for those two actions or inactions on your part?
For the Budget, none, because it's totally harmless. I'm
So
sorry.
there isn't
we-
even a breach of contract cause of action for that,
No, there is not.
let alone fraud.
You can't have a breach of contract without damages. You
There's
can't.
no damage here?
No.
Really?
On the budget?
Yeah.
Absolutely not. This equipment either needed the maintenance
There
or
was,
didn't.
there was a disclosure, they questioned the disclosure, and the response by your people was, no, 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 that's a mistake. And you took that number out. And as soon as it closed, that number went right back in. I call that a lie.
It's
It's a lie.
It's a mistake, it's not intentional.
It's a lie.
It's not
It's
intentional.
an absolute lie. The exact amount.
They had absolutely no reason to lie.
Really?
Really. If they had said, yes, that exact amount
Because whatever
is in the
happened
budget,
with that budgetary item didn't give the plaintiff any cause for relief. You had made no representations about that budgetary item in the contract, and maybe it would give rise conceivably of an adjustment under the post-closing adjustment clause, but you had no liability for that.
That's correct. Whatever.
Are there
we put in
any
the-
conditions that would have otherwise, that would have occurred between the time that the contract was signed and closing that would have allowed the buyer to either not close or delay the closing because of anything that you did or didn't do?
There are a number of conditions in the contract. None of them are implicated here.
So if
Particularly
you
respect to the
committed a fraud during that time, just saying if, okay? Would that have allowed them, had they known the true information, to delay or refuse to close?
It would depend on what the fraud was. If there was an actual, for example, they have a claim that the pond was not in compliance with the permit, and so we breached that particular rep and warranty. I have other issues with that, but I'm not here arguing that if that claim is valid, that they didn't have to
The
close.
actual inspection after the closing about the permit in December of 2020 showed that the pond wasn't in violation of the permit.
true.
Isn't that so?
That's correct.
That's actually not true. Because the report said you have to do X, Y, and Z in order to bring the pond into compliance, which implies it's not in compliance now.
I respect, Your Honor, I don't think you can read the report that, it says the condition of the dam is fair, which I think is inconsistent with the engineer saying it's in material non-compliance with the permit. He wouldn't have said it's fair. And then the corrective action, the maintenance.
Even if the pond wasn't in compliance, there are all sorts of disclaimers as to your responsibility, are there not, for environmental factors. The plaintiff was on their own in terms of doing their diligence about that pond. They knew there was a pond, and the pond, the typographical survey doesn't reflect what it would cost to bring it into compliance.
Not at all. And if I could just finish answering the question.
Please.
Your Honor, in the complaint, in paragraph 27, they acknowledged that they didn't need the survey because there's actually a transmitter in the pond that records the water level every day. And that was available to them. That's in the permit itself. So the notion that they didn't need the actual data that tells you the water level, but instead, if they had gotten this one-page topographic map.
Was that the only problem, the water level?
Yes, that's the only problem with the pond.
Okay.
Thank you, Your Honor.
All right.
May it please the court, Jonathan Friedman from Foley and Lardner, representing respondent plaintiff Pan West.
So under this, you want to go, you go first.
So originally on April 16th, 2020, before we get into the litigation mode, you send a letter talking about taking the issues, which there's provision for in the contract that there may be post-closing adjustments necessary, of submitting this to a neutral auditor, right?
Correct.
So what difference does it make whether the amount was $500,000, or as it turns out, it's only $316,000, and the non-annual maintenance cost, you were obligated to close regardless of that cost. The purchase agreement does not make it contingent upon that non-annual maintenance item.
The purchase agreement actually includes an express provision making the closing contingent on Rockland's compliance with its obligations under the agreement.
Doesn't section 4.4 of the purchase agreement cover the 2020 budget item?
The provision I have in mind, Your Honor, is section 8.2.
Where can I find that?
It's at page 116 of the record. And it says that the obligation of buyer to consummate the closing is subject to the satisfaction of the following conditions. And one of the listed conditions, item D, is seller shall have performed or complied in all material respects with all of the covenants and agreements required by this agreement. There were some black and white breaches here.
So it's
that
your
I'm happy to get
position
into.
that you didn't, if you had known the true state of affairs with regard to the budget and the pond, that you would not have closed. You did not have the obligation to close. Is that your position?
That is correct. We did not have the obligation to close.
This is my question to you. So that sounds like, you know, a pretty standard breach of contract claim, but how does it convert into a fraud claim?
So there is distinct conduct here that gives rise to the fraud claims above and beyond the conduct that gives rise to the breach of contract.
Yes, but the issue, but I think what you were asking is, how is the damage different?
How is it? That's exactly what I'm going to ask. Why are the damages different? Aren't the damages the same $2.6 million for the two items?
Why isn't this just a breach of contract action? Even if there were those elements of they weren't exactly honest, right? But why doesn't this just fall under breach of contract, as my learned colleague has asked?
So a few points on that. Number one, this is adjacent to the contract, and some of the damages may be related, but it arises out of different independent conduct that we spell out in our briefs. I'm happy to get.
What are the damages? But are there additional damages above and beyond the damages that flow from the breach of contract?
Yes.
Right? So it seems to me that the losses here are the additional $316,000 whatever, and the extra $2 million to mitigate the bond, right? So let's say thereabouts $2.5 million, right? Those are the ascertainable damages, it seems to me. Why isn't that just a contract damage?
As we discussed in the brief, the other piece of damages here arising out of the fraud is that we were denied the opportunity to refuse to close. And the damages in cases like this, where there's a fraud claim related to a breach of contract claim, is typically indemnification of any harm that results from the agreement.
But how could you make that claim? I mean, you look at section 5.10. Your client specifically agreed that it was not relying on any representations concerning the environmental condition of the properties being acquired. The disclaimers of reliance upon representations, except for what's specifically set forth, are like more than once and in the clearest terms.
That generic disclaimer of reliance did not give Rockland license to lie, which is effectively what it did here. A party cannot put that kind of generic disclaimer in an agreement and then withhold the very information It agreed to
What
provide.
representation did they make about the pond in the agreement?
Two representations. My red light is on. May I
Yes, you
conclude my
may.
answer? So first, section 4.12A1 is a representation that their environmental permits are in compliance, that they are in compliance with their environmental permits. They unambiguously were not. The permit, as is clear in the record, required a 2-foot
But what
freeboard.
establishes that they were unambiguously not in compliance with the permit?
The primary piece of evidence we point to,
You
Your
know,
Honor.
considering that you know what you're buying and you're undertaking that you're not relying on their representations, but you're going to do your own due diligence, and in page 99 of the record, including the facility and the real property and the environmental conditions thereon, that you're agreeing that they're not making representations about that.
So a few points on that. Number one, this appeal is coming here in the posture of an appeal of an unsuccessful motion to dismiss. We plead that the permit was, that the freeboard requirement was not met. We plead it repeatedly, clearly, in detail. That alone is enough.
So
But
it's
that's
based
not
on
all
their
that we
failure-
rely
it's
on.
based on their failure to turn over that map, which appears at page 200 in the record. How would that map, which appears in page 200 of the record, let you know that you faced over $2 million in costs to repair the pond?
What that map shows is it's the result of an investigation that was done, and at 25...
Other than that, the print in it is very, very small.
I agree with that, Your Honor. What that map shows in tiny print is at roughly 25 points around the perimeter of this 8-acre pond, what is the water elevation relative to sea level, and what is the elevation of the
So what
top...
stopped you from knowing that on your own? I mean, are you really trusting the defendant when you're buying this facility from them? You're not checking it out on your own? What stopped you, just like they did this survey to find this out, what stopped you from doing that yourself?
It did not require blind trust, Your Honor. They were contractually obligated to turn it over, and that's how we got
So that would only get you to a breach of contract, right?
Beyond their failure to turn it over, as we allege in the complaint, they specifically instructed the facility staff not to discuss anything about pond compliance or non-compliance with the buyer, my client. That's what gets you to fraud on the pond issue.
But what stops you from checking it yourself?
A party who is buying...
And wouldn't you, in buying a facility for $33 million, do your own survey?
It would be impossible and impractical to conduct a survey of every aspect of a property like this. That's not how due diligence works.
Is the pond an insignificant aspect of this property?
We had representations that we were entitled to rely on.
Thank you. You have 2 minutes, sir.
Just on the last point by Justice Friedman, they didn't need to do their own survey because they had the transmitter data, which they allege in the complaint, and which they obviously knew about because it's in the permit. And that actually tells you the actual water level. You don't have to use an unreliable one-page topographic map when they had all the information. They also knew that the pond was...
With respect to the budget, though, they couldn't have had that information. That was within your purview, right?
If the information is whether or not it was included in the 2020 budget, no,
Correct.
they would not have had that information.
So all the due diligence in the world wouldn't have revealed that.
That's true, and I'm not
But
arguing...
did you make any representations about that budget in the contract?
No, we specifically said that we are not making any such representation.
Except that when they questioned you about it, You lied.
I'm
mean,
sorry, that's
we
not
can't-
fair. That's not a fair
Also,
inference.
It's not a fair inference.
No.
You include it, they question you about it, you say, no, that doesn't apply now.
Did you have any motive to lie about it?
No, not every
Didn't
misstatement
matter.
is a lie.
The contract.
It's a mistake.
It's a misstatement.
Yes, not every
Really?
yes.
You submit it, and then when they question you about it, say, no, that shouldn't be in there. That was a misstatement.
Correct. And here's why. Here's why. If they had asked, if we had said, yes, it is correctly in there, there's $500,000 worth of non-annual maintenance costs, it would not have changed anything. We had no
There was
reason to
nothing
hide
they
those
could do-
costs.
There was nothing they could do about it under the
Yes,
contract.
we didn't agree that there wouldn't be non-annual maintenance costs. There was absolutely nothing to gain.
There wasn't a non-compliance that would have allowed them to otherwise not close?
No, there's no obligation that there won't be.
What about the provision that your adversary read, that you had to be in compliance with your obligations under the contract in order for, or otherwise they didn't have to close? That existed in the contract.
Yes, you can answer.
I'll tell you what's wrong with the theory on 8.2D. Their theory is that the only reason that they could have walked away is because of the alleged breach. Meaning if we had said what they say was the truth, yes, the non-annual maintenance costs are going to have to be performed in 2020. There's no 8.2D and there's no right to walk away.
There's nothing they could have done
maybe
about
so.
it because
Correct.
there was no representation about it.
Correct. And it's not, everything has a materiality
You're
qualifier.
sophisticated parties who wrote a contract, and while you say now there's nothing they could do about it, they had a right under the contract to walk away. Didn't they?
But the problem is, what provision gave that to them? No one, not the
weren't in
plaintiff, not
compliance.
Supreme Court, no one has been able to point to something in the contract that says we had a right to either demand a reduction or refuse to close. It does not exist. And it makes sense that parties we would have never agreed to limit our right to sell the property based on whether it needed $500,000 in maintenance out of a total annual budget,
Couldn't you have
$46 million.
otherwise put that in the contract, though? You said we would never have agreed. We're looking at the contract provisions themselves. That's not a we would never have.
Yeah.
Well, no, it
That's
says,
what did you do? So I still haven't really heard from you why the general provision that says you must be in compliance with your obligations under the contract in order for a closing to go forward, why that doesn't apply? Why doesn't it
2
apply?
points. We have specific disclaimers that say we make no representations about maintenance or the equipment, and all of it is as is, where is. And the second point is that there is nothing in there that which says having this item in the budget is a breach. So much less a material breach. It is not a breach to have the maintenance costs in the budget. We could have had maintenance costs of $500,000 or $500 million.
I mean, isn't it self-evident that there are going to be maintenance costs on this project?
Of course. And remember, we're talking about a pro forma budget for 2020. That's it. So, if the answer is this stuff needs to be done in 2021, it's not even pertinent to what we said.
Okay. Thank you.
Thank you, Your Honors.
People v. Anthony DeBelis. You may proceed.
Good afternoon. May it please the court. Matthew Bova for Mr. DeBellis. I'd like to start with the ineffective assistance of trial counsel point. Defense counsel here at this trial had one factual theory, that Mr. DeBellis was driving to the police precinct to surrender a firearm to the 49th precinct of the NYPD under the buyback program, the long-established buyback program. But instead of pursuing the only defense that was tailor-made for this precise scenario, which is a statutory voluntary surrender defense under the penal law, counsel instead...
Why would that be a viable defense where it's conceded that he lied to the officer about even having a gun in the first place? If he was really going to return the gun, why would he lie to the officer and say, I don't have any gun?
Well, that is a classic question of fact that goes to the jury. That is exactly the kind of argument the prosecution could make and did make in the summation. prosecution can argue, certainly, that Mr. DeBellis is...
If you have to show ineffective, you have to show that it was a viable defense. And here, with the record says, not only did he lie about having the gun, when the gun was found, he says, oh yeah, he admitted it's mine. Both of those things totally undercut any viable defense that he was just going to return the gun.
Well, Mr. DeBellis testifies that no good would have come from openly admitting to the officer upon being pulled over.
But then what evidence was there to support that argument to a jury?
Well, because Mr. DeBellis squarely testifies.
And that testimony was rejected by the jury. So why, I just don't understand.
No, Your Honor, that testimony was not rejected by the jury because there was no defense presented to the jury that put that testimony in play. Because counsel went all in on an obviously baseless temporary and innocent possession defense and failed to request the voluntary surrender instruction, which would have put this issue of fact before the jury, there was no defense at all presented to this jury. This was effectively a directed verdict.
I guess what puzzles me in this case is that you brought it as a direct appeal claim of ineffective assistance of counsel. And to me, this seems to be laden with some tactical decisions or not. But we can't really tell from this record, and I don't see it as being the exceptional case, or I don't understand why this is the exceptional case, that it's so apparent from the record that we should find ineffective assistance of counsel.
Because there is no conceivable reasonable strategy that would justify failing to pursue the only valid defense in the case and instead conceding guilt before the jury. There's no plausible strategy at issue here. This is exactly like this court's decisions in Logan and Holland. Those are direct appeal and effective assistance cases where because counsel is ignorant of the law, he pursues one baseless defense instead of the only valid defense.
Counsel, didn't the court at sentencing find that there was no gun buyback program at the time?
Well, Your Honor, that's not necessarily a finding because the issue was never presented in a clear form.
Yeah, but it was in response to the claim that he argued with respect to the defense you're raising, that I was volunteering surrender, and then the court observed there was no buyback program at the time, which really undercut the whole defense.
Well, because there's no basis in fact for that claim. To the extent the court was suggesting in kind of an off-the-cuff remark that there is no New York City buyback program.
Are you saying that there is an ongoing 365-day-a-year buyback program in New York City?
Yes, Your Honor, but that's not what I'm saying. That's what the city's own websites say. The city's websites very clearly say, and this court can certainly take judicial notice of public New York City government websites. And also Mr. DeBellis testified to this effect that there was a buyback program. But those websites say that that 24 hours a day, every day of the week, a person can surrender a firearm to the New York City precincts in exchange for cash at certain precincts. And even if they can't get cash at certain precincts, they are still able to surrender it with no worry of criminal prosecution. That is the whole purpose of the buyback program that has existed in this city for 20 years now.
Okay.
Thank you.
Thank you. You may proceed.
May it please the court, Daniel Young on behalf of the people. Good afternoon, Your Honors. Counsel here was effective. As the sentencing court noted during sentencing, it would be a hard press to find anything else that Counsel Alexander Sanchez could have done to possibly benefit the defendant.
Well, that's just a general conclusion. Let's get to the nitty-gritty of the argument that's being made here, which is that there was testimony from the defendant, whether believable or not, but it was before the jury that he owned the gun and he was bringing it to the 49th precinct. Was that enough to otherwise get him the jury instruction regarding the buyback program?
It is not enough, Your Honor.
Why not? What was deficient about that?
Here, when the defendant was pulled over by the police, on multiple occasions he denied having a firearm and in fact went so far
Well,
as
that
to...
just makes it an issue of fact. Is he credible or not credible? So, you know, what element was there no evidence whatsoever that would at least raise a question for the jury to consider?
There was no evidence that he was actively engaged in turning that gun in. The exemption does not apply if you are merely stating that I, in the future, plan on turning this in. And in fact, the case that defense relies on...
Is that what he said?
I'm sorry, Your Honor.
Is that what he said in his testimony, that he was going to give it back at some future time, as opposed to, I was on my way to the 49th precinct to give it back?
No, Your Honor. He said that he was on his way to the 49th precinct to turn it in. But what I'm saying is, at the time of the stop, he made no indication that he was even attempting to turn it in. And as the case...
Is that required?
Yes, Judge. You would be...
That's required, that he say it at the time that he stopped? Otherwise, he's deprived the defense, even though that's what he was actually doing?
Your Honor, he was not stopped at a gun buyback. He lied about having the gun entirely, and he made every effort to obfuscate the existence of the gun. There's no credible indication in the record that he was actively engaging in bringing it to a gun buyback. Furthermore...
Yes, but her question was whether he was required to tell the police officer when stopped that that's what he was doing. And the answer to that question is no. There is no affirmative obligation that he tell him. He should have, but there's no requirement that he tell him.
That is correct, Judge, but by doing so, by allowing a defendant to, after the fact, state that he was bringing it to a gun buyback, you would essentially allow any criminal to immunize themselves from prosecution.
We cannot stop a defendant from asserting whatever defense they wish to assert. You and I both know that, right?
Yes, Judge.
So the issue is whether the defense has been made out, and that's what we're arguing, right?
Correct, Judge.
Okay.
However, here...
Part of the reason that this all comes up is because this happened to be a defendant who testified, right?
Yes, Judge.
So I'm not sure that it would have the wide-ranging effects that you're talking about, that somehow there's a public policy reason to deprive a defendant who gets on the stand and says, this is what I'm doing, from at least having the jury consider the question.
Even from that standpoint, Judge, the defense was able to present, or attempted to present, a temporary lawful possession defense, stating that the lawful purpose was to turn the gun in at a precinct.
Right, he was going to develop it, and then the court didn't allow him an instruction on that either.
That is correct. Ultimately...
So now, but here's the thing. We're not here on that as an error here, that it was asked for and not given. We are here on an ineffective assistance of counsel claim, right?
Yes, Judge.
And it's certainly conceivable that his attorney, knowing his record and knowing that this may not be believed because there was such scant evidence, and in fact, evidence that was really to the contrary, that this would not have been a good defense to put forward, right? That it could have been a tactical reason that it wasn't put forward.
Exactly, Your Honor.
And we don't know that because we're trying to determine this, gain this from the direct record on appeal rather than a 440 motion, how these are usually made, where the attorney might have an opportunity to explain tactically why he thought it would have been inappropriate to ask for a defense like this.
That is correct, Your
Right,
Honor.
in fact, his attorney here is just assuming he was ignorant of the law. We don't know that.
Yes, that is speculation at this point and something that would need to be further explored by way of a 440 motion and potentially a hearing. I see my time has run, so I would ask this court to affirm the conviction. Thank you.
Thank you so much. Counsel, you have 1 minute.
Why shouldn't there have been a 440 motion here?
Because the record conclusively shows that counsel was not rejecting this factual theory because he found it incredible or unbelievable or that it wouldn't sell with the jury, because he pursued that exact theory under the banner of a baseless temporary and lawful possession defense as opposed to the statutory defense. He then hammers home this voluntary surrender point in summation in pursuit of a mercy plea, when what should have happened was he should have had a defense instruction that gave the jury a real issue to resolve so that instead of a directed verdict, we had a real jury trial where the jury assesses credibility and comes back with a finding of fact on the actual defense that applies. So we don't need a 440 because the record conclusively shows that counsel is not making a tactical
But when the
call.
record, but when the record shows that there's no reasonable view of the evidence that would satisfy the defense, shouldn't we have had the benefit of what counsel's thoughts on this subject may have been?
Well, no, Your Honor, because there is a reasonable view of the 265-20 statutory defense, because that statute requires that a person be voluntarily surrendering the weapon to the NYPD buyback program. People versus Watson, second department authority that was in effect a year before.
When he stopped, and I understand you are going to contend that there's no requirement that he say anything, but when he stopped, it's not what he says. He denies having a gun.
And that is the
He
credibility,
secretes it.
and that is the credibility issue that goes to the jury. This isn't a case where you have two inconsistent defenses and counsel's choosing one version of the facts instead of another that he finds more credible. This is one version.
But an attorney is not required to put forth a potential defense that may be a losing defense because he knows that there are such incredible mountains to climb on issues of credibility, right?
He is required to do that, and any reasonable lawyer would do that when it is entirely consistent with the defense's actually chosen factual theory at the trial. That's what makes this case very unique. It's not like counsel rejected self-defense because he found it incredible and instead went all in on identity. Those are two separate factual theories. Here we have one factual theory, but counsel just chooses the wrong legal defense, and as a result, we get a directed verdict against Mr. DeBellis and functionally no jury trial at all.
Thank you.
Thank you.
Cohen versus Getzel.
Shouldn't we say something about 440 in this decision?
You may proceed.
Good afternoon. May it please the court. Patrick Lawless for the defendants, appellants, respondents. We respectfully request that this court reverse the order of the Supreme Court which denied their motion to dismiss the complaint. First and foremost, the second cause of action against the defendant should have been dismissed as barred under the doctrines of collateral and judicial estoppel. The plaintiff entered a plea of guilty to tax evasion. In entering that plea, the federal judge advised the plaintiff of his rights, explained to him the consequences of his plea, and more importantly, when the plaintiff entered his plea, he specifically stated that he intentionally filed a tax return even though it did not reflect certain income that he received, and he knowingly did so with the intent to evade paying taxes. He now alleges that it's the Getzel defendant's fault because they didn't include this information on his tax return, and had they done so, he would have paid his taxes. But that is specifically precluded by his guilty plea, because whether he intentionally withheld this information from the Getzel defendants or there was some error, he intentionally filed the tax return while knowing this information wasn't contained on the tax return with the specific intent to evade paying taxes. So under those principles, the second cause of action should be dismissed. With respect to the first cause of action, the plaintiff was assessed 2 fines for the failure to make estimated payments. The first fine was for just under $2,000, which he admittedly stated that he never pays estimated taxes, and I don't think he refutes that he can't recover for that. And then the only other fine was for approximately $394, which there was an outstanding balance that the Getzel defendant specifically said that would be applied to that. So he didn't suffer any damages as a result of that.
But he never denied that in his papers, that he got a credit for the $393 and change. Did he?
He never denied that in his
Never
papers.
denied it.
Yeah,
Right.
exactly.
And you're saying that even if there was malpractice on that first cause of action, at most, that could be the entire recovery.
Exactly,
Because
Your
he
Honor.
would have been otherwise obligated to pay the taxes.
Exactly, Your Honor.
Right.
That's it. Unless you have any other questions, I'll reserve my remaining arguments for my rebuttal.
Thank you.
Thank you. Good afternoon, Your Honors. Daniel Wolf on behalf of the plaintiff and the cross appellant Michael Cohen. There are three issues on the cross appeals here of defendant's motion to dismiss. I'd like to start with the guilty plea proximate cause issue, and in particular, defendant's argument that plaintiff unambiguously stated that he alone was responsible for the missing income at issue in this case.
Well, whether he's alone responsible is truly irrelevant. The question was whether his failure to report was voluntary and intentional, and he admitted on the record during his allocution that his failure to report was, I quote, voluntary and intentional and done with an intent to evade or defeat the calculation or payment of the tax.
Well, respectfully, Your Honor, I would submit that whether he alone was responsible is precisely what's at issue under New York's comparative negligence standard.
But the better, he didn't admit in the criminal proceeding to negligence. He admitted to a willful act. There wasn't negligent. I mean, he was a man who owned taxi medallions. He got lease income for it, and he didn't report it. He didn't report it to the federal authorities. It's astounding, quite frankly, but it is what it is. But we're not talking about negligence here. We're talking about his willful conduct that was admitted.
And he had been advised by the defendants here what his estimated taxes should be, and he failed to pay them.
Well, the estimated taxes are separate and apart from this income.
Counsel, the entire reason we're here is because he didn't do that, right?
Well, no, there's two separate issues. There are, Mr. Cohen earned annually significant income from leasing taxi medallions,
right?
Personal loan.
And then interest on loans. I got it.
He provided.
Was his business. He was a taxi king, right?
Correct, and
right.
the defendants
and
were well aware.
He didn't know that he had to report that income to federal authorities? Really?
Whether or not he did, the defendants can also bear liability for that under the comparative negligence test. There are numerous cases in New York.
We get down to the fact that there is an admission that he didn't pay willfully and intentionally. That's not negligence. How does that fit into the rubric of negligence? You can't have comparative negligence if there's no negligence to begin with. Right? That's a fundamental aspect.
The statute is clear that intentional conduct by the plaintiff will not bar recovery. Admittedly, the term is comparative negligence. The statute and the cases interpreting it are clear that even in cases...
Let me see, if you commit an assault, you can't then get somebody else on the hook for that, an intentional tort.
So respectfully, Your Honor, there's actually a case in our brief where the plaintiff swings first with a club and then is hit with a baseball bat and recovers, and certainly prevails on a motion to dismiss. And precisely for this reason, this is an issue that goes before the fact finder. And the fact finder may find that for the reasons...
What could they find? That he negligently didn't report his income in light of the criminal conviction? They could really find that.
Under New York law, an accountant has a duty, among other things, to save the client from himself. And there are cases finding that failure to give adequate warnings constitute proximate cause. I would submit that under those cases, the actions of these defendants, at the very least on a motion to dismiss, there's a sufficient showing of proximate cause. And in the accounting context, this court and others have said that a client's conduct will bar recovery for accounting malpractice only when that conduct has contributed to the accountant's failure to perform his contract and to report the truth. There's no indication of that here.
whatsoever. The defendants were provided with the documents that showed this income. They had a duty to investigate those documents. They failed to do any investigation. They breached that duty. They did not include this income.
Wait. So you give every year, millions of people in this country give their documents to CPAs and accountants. You're saying now that a CPA or an accountant has an affirmative duty to investigate all of their clients' papers to make sure that everything in there has been properly reported by the client. That's what you want us to hold?
Can I answer that?
I asked the question.
These defendants were retained specifically for their expertise in the taxi medallion business. We're well aware that this is a significant source of income for my client and recorded $0 in his tax returns for every single year for that taxi medallion income. It's at least a factual issue whether that is a breach of their duty.
Okay.
I'll just be very brief. The issue here is not whether the Gessel defendants, again, whether they weren't provided with this information, whether they failed to investigate, or whether they committed negligence. The issue is that at his plea allocution, the plaintiff specifically stated, I knew when I filed these tax returns that this information wasn't contained there, and I did so with the specific purpose of evading paying taxes on that income. That severs any causation, and it also precludes the plaintiff from bringing this claim against the defendants.
Thank you.
Thank you.
You have 2 minutes if you wish.
I would just note briefly for the court a number of cases cited in our brief where accountants are found liable in cases where a client was either aware that there were accounting errors or involved in culpable conduct. In Shapiro v. Gleckel, the accountant...
Did it involve, did those cases, any of them involve criminal either convictions or pleas?
None of the cases in the
Not
accounting context did. There are cases in our brief involving criminal conduct outside of the accounting context, and I would submit that looking at those two cases
That plea
together.
allocution is quite a barrier to overcome.
Yep.
Well, again, I would respectfully submit that there are a number of cases, and I won't detail them now, but they're in our brief, showing in the accounting context, there are clients who knew of accounting errors, still prevailed. Again, we're on a motion to dismiss here.
Yes, the difference is your client pled guilty and allocated to it, but I thank you.
Thank you, Your Honors.
Gimbel versus Leonard. You may proceed.
Good afternoon, Your Honors. Justin Catan for the appellants, trustees, Stu Leonard Jr. and David Erlinger. Removal of a trustee is a drastic action, and a court can only remove a trustee based on serious misconduct.
Sir, was the trustee removed here?
Well, the trustee has been removed, yes, at least temporarily, although that temporary suspension has now lasted about 10 months or 8 or 9 months.
I thought they added an additional referee, not removed the ones that were there. Am I incorrect about that?
So my two clients were removed as trustees temporarily, and a temporary trustee was put in their stead. So as of now, they have no access to any information or anything like that with respect to the trust. So yes, they were removed.
They engineered the removal, did they not, of Jeffrey as manager of the LLCs? Is that correct?
No, that's also not correct, Your Honor. Jeffrey is still the manager of all three LLCs. What the amendments to the LLC operating agreements did was
had him report to them, which changed the entire nature of his control prior to their maneuvers.
so under the trust agreement, the trustees had the right to manage and direct.
So what was the justification for that maneuver?
I'm sorry, can you just say that?
What was the justification for that maneuver against Jeffrey by the trustees?
The justification, so this is now outside the record on this motion to dismiss, but the justification for it in the trustees' view at the time was that they wanted to require greater disclosure because they felt that they and the beneficiaries of other trustees were not receiving appropriate
Jeffrey
disclosure.
had investment opportunities. Wasn't cash allowed to remain uninvested by the trustees?
So there is, I don't know what it is today, but there is an allegation that there is, I think, $1 million that was not invested. That is not, however, a basis for removal. That isn't,
But the conflict and the attempt to take advantage of an investment opportunity as a trustee is.
If what you're referring to is Mr. Erlinger.
You know exactly what I'm referring to, yes.
I understand. So Mr. Erlinger, there's the allegation that Mr. Erlinger, at the time that he was a trustee, sought to ask Jeffrey's permission or approached him about
He sought to take advantage of that investment opportunity.
He approached Jeffrey to see if it could be available to him. There is nothing untoward or improper about that, nor did it create
You know, I think we're missing the forest from the trees here in this respect. This is a motion to dismiss. Your clients may or may not ultimately be removed. And we have to have a hearing on that, including, I believe one of the reasons that the lower court put in the temporary guardian was to ensure that there would be an orderly production and exchange of documents and materials so that each of the sides would have the ability to otherwise stake out their positions of whether this was a breach of fiduciary duty that would have required removal or some conduct that would have required removal and or not. You know, so now we get your motion to dismiss and a temporary receiver or a temporary trustee has been put in. And I have to say, I too thought when I looked at the record that what the court had done was had this trustee come in as an additional trustee just while this action was pending so that your clients really were not deprived of their fiduciary duties while this was ongoing until we get kind of a disposition.
that is just not, that's not the case. What the,
All right, I'm gonna ask, and the reason I'm asking is because I'm gonna see if your adversary sees it the same way, in which case I will say I am incorrect, and then that might change the calculus on some of this.
I want to go back to something that was touched upon. It seems that it's undisputed that your clients amended the operating agreement, so they didn't actually take over control, but that gave them the ability to take over the control and management of the day-to-day operations from the beneficiary of the trust. Isn't that alone by itself enough to create the basis for having a hearing to see whether there's a conflict? Because clearly the original intention of the father was to have his son manage the business, and all of a sudden things have happened so that that right could be taken away from him in any day. Isn't that a problem enough so that a hearing should be had to see whether there really is a conflict?
Let me just add to what my colleague has just said, especially in light of the fact that everyone agrees that he was managing the company just fine, that there were no issues with respect to the management of the company.
Okay, so first of all, it is not justification for a hearing. It is not justification for a removal because there is no misconduct simply by amending an operating agreement. This court has held in the matter of Rudin case, that it is actual misconduct, not a potential conflict of interest, that justifies removal of a fiduciary. So as a matter of law, merely amending the operating agreements isn't wrongdoing. And more importantly, here the key is that there was no misconduct as a result of these amendments of the operating agreement. The court below found that what the amendment of these operating agreements did was constitute potential self-dealing. That isn't the case. Mr. Leonard has no financial interest in these LLCs, and that didn't change because of these amendments. Mr. Erlinger has only a de minimis interest in these LLCs, and that didn't change because of these amendments, nor could it change because of these
Except that this amendment would allow him the right to intervene in the management of the day-to-day operations based on the amendment of the operating agreement, correct?
The amendments do give Mr. Erlinger and Mr. Leonard greater oversight over Jeffrey. However, there isn't that, number one, that is something that is expressly allowed by the trust agreement. And so there isn't, that can't be misconduct as a matter of law.
Counsel, it wasn't that long after this man died that this change of the operating agreement occurred.
It was a year or two, that's correct.
So, I mean, you know, that I think that is something for a jury to look at and consider. But you'll have time on rebuttal.
Thank you, Your Honor.
Afternoon, Your Honor. Michael Sullivan for Jeffrey Kimball.
So I just want to straighten out the factual issue. There's a temporary trustee that was put in place by the lower court, right?
Correct, Your Honor.
All right, and is that temporary trustee acting alone?
Your Honor, I think the question you're asking is whether anyone has been removed.
No, that's not the question I'm asking. Does the temporary trustee have the right to act alone?
I haven't considered that, Your Honor. But I believe Mr. Sumis is acting, it is my belief, it's not in the record, I believe he is acting without consulting directly with the other trustees. I believe he's been approached by counsel, but not the trustees themselves.
But the court didn't expressly say that the trustees that are in place would act together with this temporary trustee.
That's correct, Your Honor.
Okay. That straightens it out for me. I was under a misapprehension.
The court appointed Mr. Sumis at the conclusion of argument. At the conclusion of argument in August on petitioner's motion to dismiss, the court invited comment on her suggestion that a temporary interim trustee be appointed. We readily agreed. Counsel for the petitioners here expressed preference to consider successor trustees that are identified in the trust instrument themselves.
Yeah, but this is all besides the point. The point is that you put in somebody temporarily until we straighten out and get a disposition on the underlying petition, which is to remove these trustees.
Exactly, Your Honor.
Right, and so the issue in front of us is, given the allegations that you have made, are they otherwise sufficient for the removal of a trustee in New York State? That's it, pure and simple. You get the benefit?
Yes, Your Honor.
Okay,
why? And I think against the relevant pleading standard, we've more than pled a sufficient basis for removal. Discovery will bear out the validity of those assertions, but certainly we've alleged self-dealing. And with respect to one particular subtopic that captured the panel's attention, I take issue with my friend's assertion that they were entitled to amend these operating agreements. The trust agreement, the trust instrument, in fact, does not authorize that provision. Article 9 contemplates involvement, management in LLCs in which the trustees have an interest, a financial interest. That isn't the case with respect to any of these, certainly not Gimbal 1 or Gimbal 2. With respect to Riverside, We think.
So your claim is that they're acting in excess of their authority under the trust instrument,
Absolutely, Your
and
Honor.
that's why they should be removed.
Among other reasons, Your
But
Honor.
you're not claiming this particular action resulted in any financial benefit to them. In fact, quite the opposite.
Your Honor, there's a lovely line in Rothko that talks about a trustee's aggrandizement to himself of opportunities, positions, reflected glory to which that trustee would not otherwise be entitled. And that certainly is what we suspect is going on here, that these trustees, in fact, are looking to bask in the glory, the glow of substantial real estate investments to which they would otherwise have at best a minority passing derivative interest, and only in respect to one of those LLCs, Riverside.
So your answer is no, you're not claiming a financial interest, you're claiming an interest in glory.
Yes, Your Honor.
Okay.
Yes, Your Honor.
Okay.
Thank you. I have nothing more to add, but I'm happy to respond to any questions.
Thank you so much. Counsel, you have 2 minutes.
First, Your Honors, we had several rounds of briefing in the lower court, and we've had I don't know how many pages of briefing in this court. This is the first that I have that the petitioner has raised that the trustees have acted in excess of their authority under the trust documents. They have never argued that before right now. And when you look at the trust documents, it's clear that they did not. So that's number one. Number two, let me be clear. My clients have been removed as the trustees. It's not part of this record, but I can tell you that every time they've tried to email the trustee or the temporary trustee.
Well, that seems to be, I don't know if they were removed or not, but it seems to be conceded that the only one who's acting here is the temporary trustee.
That is correct.
And that sounds to me like, whether it was specified or not, that your clients were removed, that seemed to have been the intention of the underlying order, that pending determination of the underlying petition, that a temporary trustee would go in and make sure everything was kind of operating.
So that is correct, that was the intent of the order, but that's not proper, because in order to remove a trustee, even temporarily, there has to be a finding with undisputed fact of serious misconduct. Here, that removal of my client...
Even temporarily?
Yes, there is no...
While we're trying to sort this out, the court has no discretion to issue an order that kind of, calms the waters, as they say, really?
Not based solely on a petition. The case law uniformly says that it has to be done, that removal has to be done on a finding, on a showing of serious misconduct. And when there's...
I'm sorry, but on August 31st, when the court issued that order,
right,
2021, did the court say, I am removing the two trustees? Yes or no?
I don't remember the specific language, but what the court did, the court made clear that my clients are not to operate as trustees while the temporary trustee is acting as temporary trustee.
But that's not removal. That, to me, in my mind, and I forgive the analogy if it doesn't quite work, it's like appointing a receiver. The receiver doesn't take title to the building. The owners still own the building, but the receiver is there to make sure it continues to operate pendente lite until there's some kind of resolution at the end. Is that a fair analogy, or it's not here?
It is not a fair analogy, because ultimately they have been removed. Currently, they have no rights in and to exercise their fiduciary obligations.
So why have you not moved before the court, since it's now April 2022? I mean, if your clients have been struggling, why didn't you move by order to show cause to say, Judge, I need clarity here. My client can't do what they're supposed to do. Where are we going?
The judge made it abundantly clear. There was no ambiguity with respect to the court's order, and certainly the temporary trustee has not acted as though there's any ambiguity.
Can you give us the exact reference in the record to what you're relying upon for that? I want to look at it again. Sure. This is of concern to me.
Bear with me one moment.
Your Honor, page 31 of the record is where the court announces an intention to appoint
Okay.
Thank you.
Actually, if you may, because I think there was a subsequent, just bear with me 1 second, if I may.
All right, we're out of argument time. Why don't you give whatever additional pages to one of my officers, and they'll communicate that to us, okay? So we can go forward with arguments.
Will do. Thank you, Your Honor.
Thank you so much. PBA versus City of New York. You may proceed.
Good afternoon, and may it please the court. Claude Platten on behalf of the City of New York. Excuse me. The diaphragm compression ban prohibits a well-known, potentially deadly form of arrest restraint. The NYPD.
What do the police department regulations provide about this subject? Isn't there a provision in the regs of the police department in terms of diaphragm compression?
There, in the patrol guide, Your Honor, there was for at least for decades before this statute was enacted.
And how does that compare to the statute?
It addresses the same conduct, sitting, standing, or kneeling on the chest or back in a way that impairs breathing. It doesn't specify the mechanism of injury the way the statute does. It doesn't say by compressing the diaphragm. And the NYPD has continued to train officers on the same conduct both before the statute and after, because that's the sure way to avoid causing this harm. But the statute is I'm sorry, Your Honor.
You can finish your answer.
No, I'm saying the statute is different in that it adds an element specifying how this impairment of breathing occurs, but it doesn't change what officers are supposed to do. And they have clear notice, just like they did before, of what's the danger is and what's prohibited. But now the City Council intended for that to be criminally prohibited because the policy wasn't having the intended effect.
So the police patrol guide is more stringent in that it has an absolute ban altogether, strictly, of kneeling, standing, or sitting on someone's back or chest. You just are not supposed to do it, correct?
That's correct.
And so the statute adds this additional language, and based on my understanding of the record, that language was added and falls under what I would call no good deed goes unpunished. The City Council, in an attempt to address the concerns of the police department, the fear that if an officer fell on top of a defendant during a struggle, that would be perceived as an act that they could be liable for. And so in consideration of that concern, this additional language was added, which in my mind helps provide the police department with a defense.
That's absolutely right. And I want to clarify one thing about my prior answer, Judge, which is the patrol guide said to avoid doing this. It didn't say it was prohibited. And this statute does prohibit it, but also, as we've made clear, there's a justification defense available to an officer. So just as before, if an officer determines that reasonably believes that they truly need to use this sort of restraint to protect life, to effect an arrest, they can make that judgment. It's not a flat prohibition in all instances. It is possible to use this if it is truly necessary. And if an officer is charged with this offense and they interpose a justification, charged with the offense and they interpose the justification, the prosecution has to disprove that beyond a reasonable doubt. So, I'm sorry, Your Honor.
No, I'm just going to get to this, and because I've been struggling to kind of understand this. Part of the underlying decision and the petitioners, what they're concerned about is that you can't tell if there's diaphragm compression, that you can otherwise kind of stand or sit or do something to somebody's back, and it doesn't necessarily have to be diaphragm compression, and you couldn't tell. So here's my question. Isn't this otherwise modified by the precatory language here that it has to obstruct breathing? And isn't that observable?
That is absolutely observable, Your Honor. And officers are trained to observe this, And that's the notice. And this is
So
really,
if an officer was, and this is just hypothetical, if they, for some reason, were putting pressure on somebody's back near the diaphragm, and there were no outward signs of the person's breathing being impeded, would that be a violation of the statute?
to prosecute, the prosecution would have to establish beyond a reasonable doubt that diaphragm compression occurred. They would probably do it with expert testimony. But the point is that the officer in that situation is on notice. If they're kneeling on someone's back, if the person observably can't breathe, they're on notice that they might be violating this statute. And in that sense, this statute is not different from many others, which set an objective standard that may be hard to figure out exactly where you fall relative to that standard. And I'll just point to the analogy that I think is the best one here, which is the DUI statutes.
Exactly.
And and the courts have rejected these vagueness challenges to DUI laws. And they've said, if you drink and then you get behind the wheel, you're on notice that you might be in violation of the statute. And the fact that you can't know that where your blood alcohol level is does not make that statute vague.
It says proceed at your own risk.
Proceed at your own risk. And that's what this statute does too. And an officer should be on notice that if they're doing this conduct, which is deliberate conduct, it's not the idea that you can inadvertently violate the statute is just not correct. You have to deliberately choose to kneel on someone's back, to sit on that person. You observe that their breathing's impaired. And if you do that, you're proceeding at your own risk. And that's exactly what the city council wanted officers to do, is to be on notice that they should not be doing this. And the fact that it says you have to compress the diaphragm to violate the law doesn't alter the notice to the officers of what they should and should not be doing. And it may be that the prosecution has to prove that element in a prosecution, but it doesn't deprive an officer of notice about what they should and shouldn't be doing. And if they do with what the patrol guide has been saying for decades, they'll have no problem. So I'll just briefly touch on the other issues here. I hope that the court will reverse. If you don't, then at the very least, you should sever the diaphragm compression ban and reinstate the chokehold ban. Supreme Court just went too far in its remedy here. There was never an argument that the chokehold ban was vague. There's never an argument why it should.
I want to understand this severance argument too. So then your severance argument is just basically, if we agree with the lower court, then the remedy was far too much, leave the chokehold in, not just get rid of the words regarding the diaphragm compression, because that would actually impose a greater obligation than the statute otherwise provides.
That's right. We're not arguing that those words should be removed. We're saying that the chokehold ban and the diaphragm compression ban are two distinct prohibitions of different conduct, and that if there's an issue with one, it should not extend to the other, and it can easily be corrected.
Do you want to address the preemption argument?
Yes, thank you, Your Honor. So the Supreme Court got this part exactly right. The court should reject the preemption challenge. State law doesn't deprive the city of authority to prevent harm to its residents and to regulate the use of force by law enforcement officers. First, there's no conflict preemption here. The local law just covers some conduct that state law also covers and some conduct that state law is silent about. And that's just not enough to show conflict. There's no inhibition of the operation of state law. The local law just goes further. And time and again, this court and the Court of Appeals have said that this local law can go beyond what state law does, and there's no difficulty for an officer here complying with both the state law and the local law. There's also no field preemption. There's no declaration of a state policy occupying the field. There's no express need for statewide uniformity, and there's no comprehensive and detailed regulatory scheme that would displace the city from regulating. There's just scattered provisions in different parts of the penal code and the criminal procedure law that plaintiffs have pulled together that were enacted at different times for different purposes that touch on these issues, but they don't amount to a regulatory scheme that would prevent the city from stepping in. And the state legislature was concerned that the NYPD wasn't properly enforcing its own policy against chokeholds, but certainly there's no reason to draw a conclusion from that they didn't want the city to be able to address that issue and also the issue of diaphragm compression.
Thank you.
Thank you.
You'll have time on rebuttal. You may proceed.
Thank you, Your Honors. Tony Coles for the plaintiff respondents. I want to focus on due process, but Justice Gies, I want to start first with the question that you raised about the impairment of breathing. The court below was quite clear that impairment of breathing is not the issue in the statute. The statute is when is the diaphragm compressed? And it is certainly possible to have
The
impairment
whole
of
point
breathing.
of the statute is to make sure that arrestees do not have their air obstructed, either by a chokehold or by compression, having an officer sitting, standing, or kneeling on their back. That's what the statute is about.
Yes, but the words of the statute, compression of the diaphragm, in a manner that compresses the diaphragm, simply are too vague. A cop in a life and death struggle, in an arrest, is not going to know whether or not the diaphragm is
Counsel, what we're talking about here is not an officer and a subject rolling around on the floor punching each other in the face. That's not what this is about. What this is about is explicitly, you may not, Mr. Police Officer, stand, sit, or kneel on the chest or back of an arrestee.
That's not, actually,
That's what this
no,
is.
actually, Your Honor, may I respectfully disagree? Because it is a huge difference in how we approach this. This statute allows you to sit, stand, or kneel on the chest or back of an arrestee. It does not allow you to do that in a manner that compresses the diaphragm.
All right, and now we
And
do.
that's why
and
the
let me
statute
get,
is
Let me get to my question, because this is what I was trying to drive at. So, and I understand your argument. You said, gee, we can't tell. That's internal. When do we know when the diaphragm is compressed? On the other hand, it's not just diaphragm compression. It has to come along with the inability to breathe, doesn't it?
Well,
And let me finish it, because then I'll let you answer it. And isn't that observable by the officer? I'm sitting on somebody's back, and all of a sudden, they can't breathe. They're turning colors. They are gasping for air. They're telling me they can't breathe. Wouldn't that be enough for the officer to know, oh, maybe I ought to ease back to be in compliance with the statute?
Actually, I'm glad you asked that question, because it really does highlight the issue. The impairment of breathing has to be related to a compression of the diaphragm under the way this statute is written. And there is no way, impairment of breathing can be impaired for many different reasons. You can put your hand over somebody's mouth, you can do a chokehold. There are different ways breathing can be impaired. The reason this statute is vague is because it says that you're liable if the diaphragm is compressed in a manner that impairs breathing, and there is no way for anybody to tell. The evidence on this was clear and undisputed whether or not the diaphragm is being compressed.
So you're thinking it's okay to impair breathing as long in the context of law enforcement, as long as it's not a chokehold or the diaphragm is not compressed, that's permissible under this statute? I'm not sure I follow.
I'm not sure I follow the question.
Because you said to me it's not a question of whether there's impairment of breathing, right? I say if you're sitting on somebody's back where the diaphragm is located, true enough, you can't see that it's compressed. I give you that. But you could observe things about whether that person was breathing.
Yes, but you can't tell whether or not the diaphragm was compressed. The breathing may be impaired for some other reason.
Is it okay to obstruct breathing in law enforcement as long as there's no diaphragm compression?
Well, we're just looking at this bill. I'm not making...
But I'd like the answer to that question, because to me, that's really instructive here. Right? So does the police department think that it is okay, so long as it's not a chokehold and I'm not compressing somebody's diaphragm, to deprive an arrestee of breath?
No, that's not the position of the police department.
So that wasn't a hard question.
But that's not what the statute deals with. The statute says there's criminal liability if only in the event that the diaphragm is compressed and nobody can tell when the diaphragm is compressed.
Would that be a failure of proof in terms, as your
No.
adversary said?
No,
In terms
no.
of prosecution, that maybe you're right, but that problem is really something that falls on the prosecutor?
No, for two reasons.
Yeah.
First, because it's vague and you can't tell when the diaphragm is compressed, you can't have a fair prosecution. You're going to have inconsistent prosecutions because no one can tell if the diaphragm was compressed or not. You certainly can't tell, 5 months or 6 weeks later, whenever the prosecution is going to take place. And secondly, it is an impossible burden to put on police officers in effecting an arrest to determine when the diaphragm is compressed. You simply cannot tell that externally.
Isn't that the burden of the people?
Doesn't that what?
Isn't that the burden of the people under this statute?
No,
It is
no.
the people who have to establish that there was compression of the diaphragm, no?
No, the question is whether or not it is too vague on its face to even allow it to move ahead to a prosecution and to subject a police officer to prosecution under a vague law. And the law on that is clear. There is no evidence or testimony that you can tell when the diaphragm is compressed.
Thank you. You're out of time.
Okay.
Counsel,
Turn over
you
to
have
Mr.
5 minutes. You may proceed.
Thank you, Your Honor. Stephen Engel on behalf of the PBA. The law that we've been talking about here seems to me to be different from the law that was developed in the unrebutted summary judgment record below. When we talk about is it good to compress the diaphragm, nobody knows whether the diaphragm is being compressed. When we talk about is there a justification for restricting airflow, the problem with this law, in contrast with the state law, which regulates the same subject, is there is no mens rea requirement. The city below made clear that it doesn't matter whether the officer involved in a life and death struggle knows whether or not the
They're not always life and death struggles, counsel. The Eric Gardner case was not a life and death struggle, okay?
Your Honor, the point here is not that the state or potentially the city can regulate the use of force by police officers, and of course the patrol guide does that as well. The question is whether this law, which was hastily drafted, which the members of the city council said it was vague, they didn't know what it meant, which the current mayor has said was correctly struck down, which the police commissioner at the time said would be violated all the time, and of most relevance to this court and to Justice Love, the unrebutted summary judgment record contained 2 medical doctors who provided expert testimony that said an officer cannot know whether his action is compressing the diaphragm, a phrase without any medical certainty.
Can I ask you a question? Because, right, the experts seem to say they don't even, there's no medical term known as diaphragm compression, right?
Correct.
Right. So compression is what?
That's the problem, right?
Well,
the problem is not that
what is it in the normal parlance? What does it mean to compress?
Compressing, that's, an officer cannot know whether they're compressing. Compressing has a meaning in the dictionary.
Crush.
Right? Crush,
Squeeze.
Pressure. But the statute here says you can't sit, stand, or kneel on the torso or the back in a manner that compresses the diaphragm. And the problem is that a reasonable officer is not going to be able to determine that. And again, from the standpoint of the summary judgment record, which was not rebutted below by the city, 2 officers said the same.
I'm going to ask you what I asked your co-counsel, which is, so I'm a police officer. I am sitting on somebody's back near their diaphragm, and I see outward manifestations that they are unable to breathe. I can't reasonably infer from that I am compressing the diaphragm. I'm asking
No,
you.
I understood. And if the law only applied to an officer who knows that he is engaged in physical conduct with a detainee that is obstructing his ability to breathe.
Counsel, we have 3, under the, see what I don't understand is we have 3 different types of conduct. All that any police officer, right, that is functioning and walking and breathing understands. Don't sit, don't stand, don't kneel on the back or the chest, right? And the whole reason for that is fully laid out in the police manual, is that doing that has the danger of obstructing breath.
Yes.
The manual tells them, turn them on their side as soon as possible so that you don't limit respiration. So this is not, as you are attempting to paint, this amorphous concept that officers don't understand. Officers have to make these kind of assumptions all the time. They pull over a driver and they see him, he's got glassy eyes, red eyes, and various other symptomology that an officer can say, I think this guy is drunk. Does he know he's drunk? Until he does the test, no. But he's entitled to act. How is this different?
So this is different because two things. One, this is a criminal prohibition without a mens rea, without an injury requirement, which says that officers may be prosecuted for this
This is a
conduct.
criminal prohibition. Is there any entitlement, a constitutional entitlement by officers to be able to sit, stand, or kneel on the back or chest of an arrestee?
There is a constitutional entitlement to officers to defend themselves and the
Counsel,
public
that
by
was
using
not-
force,
Counsel,
Your Honor.
please. That's not what I asked you.
Right.
Of course they have a right to defend themselves. They have a hard job, and
Yeah.
we all know it.
Yep.
That's not the issue.
Yep.
They don't have a constitutional right, so they're not being prohibited from doing something that they are constitutionally entitled to do.
Your Honor, they have a constitutional right to fair notice of what the criminal conduct is. And when you have a law that is vague, that has no medical definition, that lacks an injury requirement and lacks mens rea, this violates the constitutional rights of the officers, as Justice Love found below, as was reflected in the largely unrebutted summary judgment record. If the law had merely said, you may never sit, stand, or kneel, do so at your peril, it would have been impossible for the officers to do their jobs, and that's not the law that the city passed. And beyond that...
Judge Schulman, you have a question?
Yeah, I'm just a little confused. As I understand it from the briefing, you don't have a problem with compressing the windpipe or the carotid arteries, or in other words, the chokehold band. It's the same terminology. I mean, of course, you're not going to be, you could theoretically kneel on someone's neck. You could theoretically sit on someone's neck. You could theoretically stand on someone's neck, front and back, and you're okay with that, using the same term, compression of this part of the anatomy. What makes compression of the diaphragm that much different?
Well, again,
particularly when the act is designed, and the reason for not doing this is because it could obstruct air.
Look, officers can be told, do not put their hands on someone's neck. Do not compress the neck. The diaphragm is an internal organ. The officers are permitted, as is necessary in the
So
case
is the
of-
carotid artery, so is the windpipe.
Yes, it's located right here.
Right,
located
and
right
we
there.
know that the diaphragm is right under the lung.
But it doesn't say don't touch the diaphragm. It says in a manner that compresses the diaphragm, which again, the record below established was impossible for the officers to understand. Your Honor, I'm out of time. I would like to say a word on preemption.
I'll give you 45 seconds.
And thank you. So all of this backdrop comes against a state law passed just the week before, the Eric Garner Anti-Chokehold Act, which in contrast to the city's law, did provide an appropriate balance with respect to the rights of officers as well as protecting detainees. That law was passed against a backdrop of Penal Code 3530, which specifically authorizes officers to use force they reasonably believe to be necessary in effectuating an arrest. This city's law is a narrowly focused law that only applies to arrests and only, by definition, will only apply where the officers are otherwise using reasonable force, because officers do not have any right to use unreasonable force, and the city has prohibited kinds of dangerous restraints like the state has prohibited dangerous restraints like chokeholds. And in this context, we think this is preempted because it prohibits what the state has affirmatively authorized.
Thank you.
We would ask the court to consider that issue as well.
Thank you so much. And counsel, you have 2 minutes on rebuttal.
Thank you. Just a couple of brief points.
Right, diaphragm compression, it's not a medical term, right?
Well, that's right. I mean,
That's what the record reveals. No doctor said that that's comprehensible as a medical term.
well, in this record, there's no doctor saying that. These words have an ordinary meaning. A diaphragm, we know what that means. There's no dispute. It's a dome-shaped muscle that moves up and down to facilitate breathing.
We know that.
And compressing is pressure, it's squeezing. And, you know, these...
Well, squeezing the diaphragm in and of itself wouldn't violate this statute, would it?
If you squeeze the diaphragm and the person can't breathe, and
Well,
you're sitting on
and there you said it, and the person can't breathe.
That's right.
So that's not a function of, how was it phrased before? That is, you know, an intent requirement, that's a physical requirement, lack of breath.
That's right. And
Depression, lack of breath.
an externally observable phenomenon.
Right. And the burden, right, okay.
Right, so I mean, I want to pick up on Justice Manzanet's point that there's no constitutional right here. The fallacy of my adversary's theory is that this statute allows an officer to sit on someone's chest, obstruct their breathing up to the point where the diaphragm is compressed and they just can't find that line. But that's not how it works. The statute makes clear the conduct that they should not be engaging in, they should not be obstructing breathing by sitting, standing, or kneeling, and the mechanism of injury that the prosecution has to prove is that the diaphragm has been compressed. But the point is they shouldn't be doing this at all, unless the justification defense applies, and they don't have a constitutional right to go up to that line.
Well, what do you mean by not doing it at all? You mean not sitting, standing at all?
Yes.
That's what the training manuals say. However, isn't that a more onerous requirement than where it's limited to where there is diaphragm compression?
Yes, absolutely.
It's not an at-all statute. It's not that at all.
That's right. They're already prohibited from doing this, and the liability standard is narrower. And just one last point, if I may. I just want to make clear, because my
I'm not
adversary...
sure what that means, but okay. That's all right. We have the briefs, obviously. We consider this a serious case.
Okay. I just want to make clear that my adversary mentioned the justification defense under state law. That, as I referenced in my opening argument, our position is that justification defense is available to an officer under
Even though it doesn't, this statute doesn't say that.
The statute doesn't need to. The penal law says that that's available for any offense, and the term offense is defined to include local laws.
Most statutes don't say, oh, and by the way, you have a justification defense. It's just part and parcel of the available defenses if the facts warrant it.
Exactly. It's a background principle.
Thank you so much, all of you.
Yeah.
Felipe Rusek versus Structure Tone Global et al. Who's the first appellant? Okay. CBRE.
Just letting you know.
And then P&T has a cross appeal, correct?
There's 3 cross appeals, one by Structure Tone, one by Aval, I believe.
Aval, got it. Okay. All right.
All right, good afternoon, Your Honors. I know this is the last case of the day, and we're all tired, so I'm going to keep this as brief as possible. My name is C. Briggs Johnson for the defendant appellant, respondent CBRE. I'd like to start with the Labor Law 200 claims. I think, you know, under this court's multiple precedents, because plaintiff and his coworkers created these pebbles, these minute, small...
Well, do we have evidence in the record of that?
Yes, we do.
Okay. Who created the channel? Where is that in the...
That is plaintiff's testimony on numerous pages, 616, 490 to 492, 501, 503 to 504, that plaintiff's coworkers created these pebbles through the channel.
Was that done on the same day of this accident?
That's what plaintiff is saying. I believe.
Does it say that explicitly in the?
I don't believe it says it explicitly. I
Okay.
apologize about that, but it's within a couple of days of the
So we
accident.
know that AVAL workers created the channel.
That is undisputed.
Okay.
Correctly.
We're just not exactly sure when
Yes,
the channel was created.
Plaintiff testified that he had no idea when the
Okay.
channel was created, so it could be minutes, it could be hours, it could be a day or so. We're not
Okay.
entirely clear on this record.
All right.
So if we accept that premise,
Wait, is it
then
undisputed that AVAL workers created the channel?
yes,
And that's in the record?
that's in the record, correct?
Well, the plaintiff testifies to that. They ask him, does he know who did it? He doesn't know, but they ask him, was it AVAL? And he says, yes, but a different trade from AVAL, someone else from it. He wouldn't be someone who would do it, but someone else from AVAL would do it.
Well, plaintiff was a foreman for AVAL, and he told the work, he was involved in this glass installation process.
Well, he sometimes served as foreman. There were a lot of foremans, and he wasn't a foreman on this day.
True, but he was, quote unquote, a boss
Page
on this project.
504 of the record, it would be another AVAL crew who would do that, another trade, yes, from AVAL or from another company. His answer from AVAL.
Yeah,
But
I
it
don't.
would be another trade,
I don't.
not his trade.
Yes, but I am quite clear that he said on numerous occasions that AVAL created this channel work. It's not disputed that the channels were for the glass installation work.
Oh, no question about that. That's not the issue. It's
Oh, I'm
like,
sorry.
who did the work to create the channel? When was it done? And whose job was it to clear the pebbles?
It is undisputed that AVAL created these channels on this
So
record.
plaintiff testifies that it was Structure Tone's job to sweep up.
Yes.
Do you concede to that?
I concede that Structure Tone signed an agreement that said that they were supposed to clean up the debris and the project as the general contractor.
And that's his testimony, that Structure Tone is supposed to sweep up. So what impact does it have on CBRE, Structure Tone's obvious failure to sweep up these pebbles, this concrete debris at the accident site? How does that interplay with your position?
On the indemnification argument, you're saying?
On the indemnification, and sure, and on the 241-6 or 200 liability.
Let me clarify.
Yeah, because you
We're
started
all-
on 200.
We're all trying to get a handle on is whether there can be an argument made that this is a dangerous condition versus a means and method, and which one it
Right.
is. And that goes to the 241-6 liability, although it also impacts indemnification.
Right.
So we need to hear your best argument why it is a means and method and not a dangerous condition. And that it's not just who created the pebbles, how long they were there, did it turn into a dangerous condition by the fact that it existed for a period of time? What's your best argument as to why it's not a dangerous condition versus a means and method in terms of the pebbles?
Yes, my best argument is that under Delana, Mitchell, Capabianca, and Duran, which is a second department case, the first three are first department, is that when a plaintiff or his coworkers, plaintiff's employer, create the condition through the means that they are doing the work, the manner and means of that work, this court has held that that is a means and methods case, and so liability cannot follow if the defendant did not direct, supervise, or control that work.
Except that sometimes a means and method issue can turn into a dangerous premises issue. And so for me,
yes,
I'm looking through the record to find out when did Structure Tone last clean?
Yes, and that's...
Is there any evidence of when they last cleaned?
No.
Do I have that in the record?
No, but I will say, even if this court wants to make this a dangerous condition case, there is no constructive notice for two main reasons. One, plaintiff never complained about the condition, and two, we don't have evidence regarding how long the condition was there, and notice regarding the specific condition and the specific location that this alleged condition was.
You're moving for summary judgment, right?
Yes.
So isn't it your burden to make the prima facie?
I'm
as
saying-
opposed to showing gaps? You're saying if there's no evidence as to how long the condition existed, how did you make your prima facie that it didn't turn into a dangerous condition by the pebbles existing for an extended period of time and neither CBRE or Structure Tone being aware of it or cleaning it?
I misspoke. I understand what you're saying. I'm saying under Mitchell, De Silva, and Zeres, when there is evidence that in the record showing that you cannot conclusively show how long the condition is there, under Mitchell, De Silva, and Zeres, and there is no
Our
specific...
case law says you have to establish when you last cleaned on a premises condition case.
I understand. I think there's a conflict in this department under Mitchell and Zeres. I would say those two cases don't necessarily hold that you have to have a last known inspection. And
You know how many more cases we have that say you do?
I understand that too.
Okay, so
But I'm saying based on those cases I've cited, that's not
so
necessarily
if we're not
true.
going to follow those outliers, then you're out of luck.
I wouldn't say I'm out of luck
Well,
because I think...
if you are, if you as you're the tenant, right? And
Right.
ST is your GC.
Right.
So if the GC messes up, that's on you too, no? As the owner?
As the owner of the project,
Yeah.
I'm saying I don't think the court needs to get that far because it's a means and methods case, but
Was that argued below?
Yes. Means and methods?
Yeah.
Yes, that's argued below.
Okay.
Yes. So unless there's any other questions,
As
I
to
know.
indemnification, but as to indemnification,
Yes.
putting aside all of that, where does CBRE fall in terms of getting indemnified?
CBRE falls in getting indemnity from structure tone because the agreement has a very broad trigger. It doesn't need negligence in order for structure tone to indemnify CBRE. If you read 1118 and 1119 in the record, the indemnity is acts, omissions, or negligence of a subcontractor, which is AVAL in this case, or the omissions of structure tone.
Let me interrupt you. Even if you take the outlook that this is a premises liability, the negligence here, is it not uncontroverted? The negligence lies with ST, right? They're the ones who were supposed to sweep up this debris and didn't.
Yes.
So why are you where does your responsibility for that come in terms of the indemnification?
We don't have a responsibility under the, if you're talking about the contract.
Aren't you entitled to indemnification from ST or someone lower down the line?
You're asking me, I need to show that my client did not commit negligence to get indemnification. That's what you're saying.
No, I'm not asking you that. Doesn't the evidence show that you didn't? It's not you aren't supposed to be there sweeping up. You could have labor law liability. Let's assume that for the moment.
Right.
But in terms of who's responsible for what happened, there's no question it's not your fault.
Correct.
Vis-a-vis ST, vis-a-vis AVAL.
Correct. Structure Tone said, we're going to clean it up, and they hired AVAL to do the work. So either Structure Tone or AVAL or a combination of the both are the negligent parties in this case.
Got it.
Okay. Thank you.
Thank you. You may proceed.
May it please the court, I'm Steve Arapuch for Structure Tone.
So is it, do you disagree with the fact that it was ST's responsibility to sweep up?
Contractually, yes, we were required to sweep up. Does that make us negligent in this case? No, because first of all, these were minute particles, which the plaintiff didn't see, similar to the black ice cases that I cited.
He testifies there's lots of debris about, and you don't sweep up the same day. So doesn't that make you potentially, whether it's labor law liability or not, but weren't you negligent? You were supposed to sweep and you didn't sweep.
Well, in order for there to be liability.
Talking about summary judgment now, how do you get to summary judgment on that where you were supposed to sweep and you didn't sweep, if that's true?
In order for Structure Tone to have been liable for this condition, it has to be a defect that's visible and apparent to a reasonable inspection. That means,
When was that last inspection?
well, the rule is that even if it's not shown when the last inspection was, the plaintiff is not negligent if the condition is not apparent to a reasonable inspection. So Structure Tone's workers could have come by and not seen these very fine particles that plaintiff didn't even see before his accident. He said they were minute. He was like, I looked, I would have complained if I'd seen something, but I didn't complain because they were minute. It must have been minute. He says, he doesn't even say that he ever saw them. He says, there must have been minute particles. So that is similar to the black ice. If a person could not see it, then a laborer coming along and who can't see particles on the floor would not be expected to sweep that floor. You don't sweep a construction site like it's your house.
Doesn't he also testify, doesn't the plaintiff also testify, maybe in context it means something else, that there was garbage, rock stirred, actual product, you name it, garbage containers, everything.
Well, he's talking about the general area, but not the actual area where they were working. I mean, it is a construction site, and there is debris, in the environs, but the specific area where they were working, it was not visible.
And why wouldn't SBRE be entitled to indemnification from you, whether contractual or common law?
Well, so far
there's no view here that CBRE did anything wrong, is there? They may be liable as a matter of law, I'm not saying, but in terms of whether they're at fault for something, whether they're negligent.
Let me add on to that, because there's also 200 claims here. It's not just 241.6. So that would be the issue, whether or not the 200 claims would stand.
Yes, if the court is finding that this is a condition of the work site rather than the means and methods.
Well, even if it's a means and methods case, if you didn't sweep up and you were supposed to sweep up, aren't you negligent, potentially?
Well, my understanding is that if it's a means and methods case, then that would not be an issue for. Let me quickly just talk about the indemnification issue.
I'll give you 30 seconds. You're out of time.
Thank you. Of course, if the court found there was no negligence on Structure Tone's part, then we'd be entitled to full indemnification. The court held that we were entitled, there's an issue of fact as to our potential liability. So granted conditional indemnity, but incorrectly stated that.
From whom?
From AVAL, plaintiff's employer.
Is there a grave injury issue?
We took no position on grave injury. That goes to common law indemnity. We're talking about contractual indemnity. And the point I just want to make quickly.
Is the law in this department, though, that if there's an issue of fact as to your own negligence, you can't get conditional indemnification?
I've seen
so that
cases.
Issue's resolved?
My understanding is that there are cases going both ways at this point. But I want to point out that the court erred by saying that our conditional indemnity was conditioned upon a showing that Structure Tone was not negligent. They didn't talk about, a percentage of fault, that we would be indemnified according to a percentage. They simply said we had to show that we were not at fault at all, and that should be corrected.
Thank you.
Thank you.
Okay. And you are here for?
Good afternoon, Your Honors. Shabru Mehta for AVAL.
Okay. You may proceed.
May it please the court. With regard to indemnification, I'm just going to start there. We believe that the lower court erred in granting conditional indemnification to Structure Tones, specifically for this motion for summary judgment, because the negligence issue is clearly present. There is issues of fact here with regard to Structure Tone's negligence. We don't think that there's any basis for full indemnification, specifically because there is clear evidence in the record that Structure Tone and its laborers were responsible for ensuring that the hallways were free of debris. Plaintiff also testified that he lost his balance due to the debris that was in the hallway.
And
Specific.
your argument to your adversary's argument about the visibility?
I'm
The
sorry?
visibility of the pebbles.
Visibility argument.
Oh,
Is there an issue of fact about whether it was visible enough such that they should have known to otherwise clean it up?
Well, I mean, the plaintiff testified himself that he had seen that there were pebbles on the ground. And Structure Tone, they were responsible by contract to clean up. I know that there isn't clear evidence of when they last cleaned or how often they were supposed to clean, but the fact of the matter is that they were responsible for cleaning the pebbles.
Okay.
So with regard to,
Plaintiff
there's,
testifies that he didn't complain about this at that time.
sorry, Your Honor.
Plaintiff testified that at that time, the day of his accident, that he hadn't at that time complained. There may have been complaints about it in other times, but as to the condition that existed in that day, he hadn't complained to anyone.
Not specifically that day, but I mean, there is testimony that he tripped or he lost balance on the pebbles.
Not directly to Structure Tone, right?
Sorry?
He did not directly complain to anyone from Structure Tone, right?
Not that I know of. So with regard to the other issue regarding breach of contract, we believe that AVAL did not breach contract with respect to 200 Park, Tishman Spire, and Structure Tone. I know that there's concern about certificates of insurance that were presented. AVAL did obtain the requisite amount of insurance as per the agreements. That's demonstrated not only by the COIs, but the policies, the correspondence, the workers' compensation records. Sorry?
Did you attach the policies below?
Yes, it's in the record.
I thought you only attached the certificates of insurance.
No, there was also policies and correspondence. Record 2256, 2268 to 2269, 2273 to 2356.
Thank you.
Yep. And there's also evidence in the record demonstrating that the plaintiff did indeed receive insurance benefits as well. And he testified to that in his deposition as well.
Thank you.
Yeah. Thank you.
Okay, next. You are for P&T?
No, I'm 200 Park and
Right.
Tishman Spire.
Okay. Isn't that P&T?
That's our
Okay, yeah, okay.
definition.
Go ahead, I'm sorry. Park and Tishman, that's why. Go ahead.
Okay.
Don't worry.
Oh, that's why I didn't understand.
It's our initials.
My bad.
Yeah.
You go ahead.
I wanted to really start on with the indemnification issue. We were granted conditional contractual indemnification from CBRE, but that was where it stopped. When you get over to the CBRE STI contract, it appeared that the lower court seemed to have missed recognizing the Tishman Spire as the owner's agent. The landlord's agent was entitled also to conditional contractual indemnification. That is shown in obviously we had a huge lease for many years, and
So how do
this
you
one.
get to that contractual indemnification for Tishman?
Excuse me?
How do you get to the contractual indemnification for Tishman? What's your theory, if you would spell it out?
Well, basically, the theory, first of all, I think we are entitled to it from all the other parties. I was going into the page. Okay, stepping back, if we're going to go back on the liability and the labor law issues, I do agree with my colleagues to the other than Aval's position, that when we're talking about a plaintiff who had, when he says that this minute pebble he's talking about, that was inside the channel. The channel, he and his colleagues were standing, putting this glass in it. He didn't fall. He just like wobbled on the inside, that little tiny channel where you put the glass in. So the debris, if there's debris in the area, that's not what he felt. It would have been that very minute debris based on his testimony. So starting off from there, I would definitely, I'm going to go with the means and methods. If we're going to go outside of the means and methods, then I should be recognized as an out-of-possession landlord. CBRE was the one who was doing these renovations inside the space that was totally theirs. These were their subcontractors, and under the lease, we were supposed to be identified as indemnities with any of their contractors. If reading the STI on page 1118, paragraph 10 says indemnify and hold harmless the landlord and their agent. So that's where we should be getting into STI, if it's STI. And then further.
That's under the lease, right?
Okay, 1118,
Right, so
that's
now we're talking about indemnification. What about the contract between CBRE and Structure Tone?
Okay, yeah, that's where I'm talking about, page 1118. That's STI and CBRE. But I go even further because STI then had its contract with AVAL. And it's written in the papers about, at one point they had a notice to admit with each other. They left out the back of these invoices that said the terms and conditions. And paragraph 2, and that was on page 1345, on number 2 of that page said, in the event of a conflict between these terms and the contract between Structure Tone and the owner, the more strict provision in favor of STI governs. And STI is had in that paragraph 10 to indemnify.
I'm sorry, doesn't Structure Tone contract refer to Metropolitan as the owner?
Metropolitan is our predecessor from many, many years ago.
I know that, but when you look at the ST contract, which has the indemnification clause, doesn't it list Metropolitan as the owner?
That was a factual impossibility. It said
it says it in the contract, though, doesn't it?
They were, what?
Doesn't it say it in the contract?
It mentions Metropolitan.
It refers to Metropolitan as the owner, right?
It said they were our predecessor. And I believe the lower court misinterpreted.
The contract doesn't say that it was the predecessor.
In the CBRE
in the
Structure Tone.
In the Structure Tone.
Yeah, in the CBRE Structure Tone contract, it makes reference to 200 Park and a predecessor being Metropolitan. And I think somewhere in there the court got a little confused there.
We will take a look at it. We're out of time.
Okay,
thank you. All right, and last but not least.
Thank you, Your Honors. May it please the court, I'm Richard Amico. I represent the respondent in this case. And where I would like to begin is to say that the court below had properly denied the defendant's motions for summary judgment for both 241-6 as well as 200 subdivision 1. I apologize, my glasses were fogging up.
That happens to all of us.
Talking about the 200 case first is that the court properly decided that this was a dangerous condition case as opposed to a manner and means test. And the reason why the court had reached that conclusion was because the accumulation of the material had then posed a hazard then to have created an unreasonably safe workplace for the plaintiff and his coworkers. And this had developed over time. The record is bereft of any conclusions that can be drawn with reasonable certainty to exclude questions of fact as to the time in which this material was on the ground, the type of material incomplete, and the persons that had
Right, your claim
material.
is that there's just not enough information in this record to figure out if this accumulated over such a period of time that it converted from a means and methods into a premises liability.
That's an interesting point. However, when this is not really a means and methods issue as it relates to AVAL, it is a means and methods as it relates to Structure Tone.
because yes, this is a byproduct of the work being performed by AVAL, but it is incumbent then, based upon the contractual language of the agreement between the general contractor, CBRE, and Structure Tone, to go there and keep the material off of the ground and the site at all times. And the basis for this is because it is to promote the safety of the workers. And it's interesting that the language that was negotiated between the general contractor and Structure Tone mirrors the language of the regulation from which such materials should be removed from construction sites. And the sole purpose of the structure of the statute, as well as the implementing regulations, is to prevent accidents such as this. So this is not a means and methods test that the court should apply. There's also a second exception to the means and methods test as it applies to this case, is because this court held in Johnson that a distinguishing factor, Johnson versus 953 Fifth Avenue condo, that the distinguishing factor of means and methods test is if the plaintiff is the one that had created the condition that had caused the injury. It was the plaintiff's responsibility to remove such materials, and then that would then relieve the responsibility of the owner and the general contractors from liability for causing his injuries. Here, it is a coworker, true, but it was the responsibility that was delegated and accepted strictly by Structure Tone to remove such material. That's why the court had got it right. And similarly true when it comes to the 241-6 subdivision 1 arguments is that the court had found that question of facts exist as to whether, bless you,
Thank you,
those regulations were violated and that such violations were the proximate cause of the plaintiff's injuries. If the court has any questions, I'm glad to answer them.
Thank you.
Thank you, Your Honors.
Okay. First up, everyone has 2 minutes now.
Thank you, Your Honors. I'm going to make this quick. I know everybody wants to get out of here. I just want to say also, we also saw contractual indemnity from AVAL, and we made that argument below. We made that argument in our appellate briefs, and they did not address it in our respondents' briefs. We're entitled to contractual indemnification from AVAL because in the purchase order between Structure Tone and AVAL, it says the owner and Structure Tone will be indemnified for any acts or omissions that lead to a claim, and we are identified as the owner in Structure Tone's agreement. Now, on 241-6, I will say, I also think this is kind of similar to the Labor Law 200 argument on means and methods. It's not in dispute that the pebbles were an inherent and necessary byproduct of plaintiff's work. I don't think you can say otherwise on this record. And there's plenty of cases, I think the Ghani case, which plaintiff actually misquoted to this court, where plaintiff tripped over a small stone while he was performing his work that was created either by when they were sizing the stones or they were carrying the stones, it dropped, and this court said it was an inherent and necessary byproduct of plaintiff's employer's work. And so therefore the 241-6 claim failed. I think, my adversary just said that, plaintiff has to create the work himself or the condition for it to be necessary inherent. That's not the law in this department. It's the employer's work for that to be a 241-6 claim. And also, he cites a bunch of cases where it says, this condition was permanent and this condition was purposefully laid. And I think there are cases where that is sufficient for it to fall in the realm of 241-6, but it's not necessary, and that's the important thing here. Sufficient meaning, yes, you have an issue of fact, but it's not necessary based on the Ghani case, the Cabrera case, and especially the Salas case, and the Zieris case. And so if there are any other questions, I'll rest on my briefs.
Thank you.
Thank you.
The Delana case is helpful on the issue of Labor Law 200. And in Delana, the plaintiff was going out onto a platform. He tripped over a bolt that was in the platform. The plaintiff's employer had been directed to remove all the bolts several months before, but missed this one bolt. The fact that several months passed did not turn it into a condition of the worksite. It was held to be a means and methods of the plaintiff's employer's work, for which, since the general contractor did not control those means and methods, the general contractor could not be held liable. Also, there was no showing that the plaintiff had been even part of the same trade that was directed to remove that bolt. It was his employer was supposed to remove that bolt. They didn't do it. The passage of time did not turn it into the general contractor's responsibility. And just regarding the issue of how fine this debris was, the plaintiff didn't even, initially he just said, the reason that this accident happened is because my employer took away one of the 5 workers that we were contractually obligated to have and which we needed in order to safely move this glass.
When he first reports the accident, he doesn't even mention it.
Excuse me?
When he first reports the accident, he doesn't mention it.
Right. He does not mention the debris. And then he was asked, why didn't you complain about it? I didn't know that it was there. It was minute. There was something on the ground. It must have been pebbles. It must have been something that when I put my foot down, my foot slipped, and that was when I felt something, like something happened. So it's like he didn't know it was there. He didn't even necessarily see it afterwards. He slipped, therefore there must have been particles.
Thank you.
I just want to address quickly the contractual indemnification with regard to CBRE and 200 Park. We believe that the trial court properly denied their motions for summary judgment, specifically because there is no language in the agreements that these parties required indemnification from AVAL. And more specifically, just like the lower court said, that there's nothing stated that they were intended to be third-party beneficiaries.
Okay.
Unless the court has any other questions, we'll refer it back to the briefs.
Thank you.
Thank you.
With regard to AVAL saying that we're not a third-party beneficiary, again, I go back to the fact that there were those terms and conditions. The terms and conditions directed them to be under the stricter terms from this CBRE STI contract. And as they do state themselves, they provided they're saying that they provided the insurance that was required by us, and from our 8th modification of the lease is where it switched. It made it, there had to be like 10 million of insurance had to be in there, and that's the amount that, according to their certificate of insurance, that's how much insurance they had provided. I will just want to add one other thing about AVAL. They never appeared at a deposition, so we don't have their, when they received that erroneous notice to admit from STI, they did not respond to it at all, and it is us who then came in and advises the court, no, you had terms and conditions in the back. So for them to try to speak as if they're for sure about their position on that is quite disingenuous. But I will rest on my papers, and I do hope the court does look at that language in the CBRE STI contract, because I do believe because that it said the MetLife in there, the court got a little confused in the way it responded. Thank you.
And last but not least. You have 2 minutes? You don't have to?
didn't have a cross appeal.
You didn't, do you have you had a cross appeal?
No, I don't, Your
So then, I thank you all for your arguments. Have a good night. Thank you.
We got 5 coming out.
Somebody left it back. Is that you? Nice to meet you.
Usually it's very close one.